Yes, my lord.
Yes.
My lord, I beg to mention item number 15, my lord. My lord, I pleaded another 2 weeks may be given to file affidavit in opposition. Time for respondent number 5. Item number 15, my lord.
How much time?
2 weeks, my lord.
Reply, to file reply.
No. Opposition, my lord. I am for respondent number 5.
Okay. You are standing there, so I thought you were for the respondent. Learned counsel, Mr.
But 2 weeks then. 2 weeks. Advertisement appointment has been made.
Learned
Yes.
counsel for the respondent, Mr. B. Soto, prays for 2 weeks' time to file his affidavit in opposition. Learned counsel for the petitioner, Mr. A. Sophie is present and has no objections. List after 2 weeks. Have you filed, government?
We are yet to receive instructions. We received the service copy just last month.
Then in
It was
this
filed
case,
last year, but we haven't received.
It has been served, my lord. But first day one will appear, next day other fellow will appear.
If we check the
We
last
also
order,
confused.
the court has passed a similar to serve the copies to us.
Without serving, we cannot even file.
The service copies, they are mistaken.
service copy, service for the other.
Yes.
It has been
Extra
served.
copies.
It has been served.
Extra copy.
When?
It has been served on 2nd March.
2nd March.
Yes, my lord.
Mr. M. submits that he has received the service copy and is yet to receive the and prays for 3 weeks time to file the affidavit. We'll give them enough time. You have served the copies list after 3 weeks.
Fine, ma'am.
That's prayed for. Yes.
Right, ma'am.
Much.
I beg to mention item 7. We pray for 3 weeks to file affidavit in opposition.
Petitioner.
Yes.
Learned counsel for the petitioner, Miss Such and Such present. So learned government advocate, Mr. M. Longcomer, prays for 3 weeks time to receive instructions. So prayers allowed list after 3 weeks. Yes.
Obliged.
May I please, Your Lordship?
Yes.
May I be pleased to mention hearing item number 20, 21, and 22, Your Lordship. If this matter can come up after 4 weeks, Your Lordship. There's a similar matter pending in the division bench, Your Lordship. So that is awaited. We have reflected that on the last order also, Your Lordship.
What is the WA number?
Your Lordship, if I'm not mistaken, it's 4. It's reflected on the last order, Your Lordship. Last time also it's written, Your Lordship.
Yes, any objection?
No.
Similar matters are
Yes,
pending. Learned counsel for the petitioner, Mr. Hesen Low is present. So learned government advocate, Ms. Livika, submits that similar matters are pending before the division bench. In which before the division bench being WA such and such. Okay, if you need stop. Accordingly, list the matter after 3 weeks.
4 weeks, Your Lordship. Thank you. 4 weeks, Your Lordship.
After 4 weeks.
Obliged.
Much obliged, Your Lordship.
Yes, Your Lordship. Your Lordship, I beg to mention item number 14.
1 minute. WA 2 of 25, 3 of 25, 4 of 25, and 5 of 25. Yes, item
14, Your Lordship.
14.
Yeah. Your Lordship, kindly grant me 3 weeks' time to file my affidavit.
Learned counsel for the petitioner, Miss Lauren Nolota is present. Sub-learned government advocate, Miss AIME, prays for 3 weeks' time to receive instructions. Software is allowed list after 3 weeks. Yes. The interim order passed earlier shall continue till the next date. Yes.
Your Lordship, I beg to mention item number 10 and 11 on behalf of Inauli, Your Lordship. If this matter can be listed on Thursday, she has some personal difficulty today, Your Lordship.
The pleadings are complete.
Yes, Your Lordship.
May I please,
Yes.
as per the last order,
Mm.
the state has submitted their documents for this honorable court, stating that the discrepancies has been corrected by the department and it's for non-payment of my salary. So as per the last order, this court has directed to release my salary for the month of March as well as from July 2021 till up to date. But since the
You'll see the concerned advocate is not.
yes, Lord.
Learned counsel for the petitioner, Mr. Sergeant is present. Stop. Learned government advocate, Miss AIME, prays that the matter may be listed on Thursday,
Yes, Your Lordship, Thursday.
on 23/4, as the council conducting the matter is indisposed.
Yes, Your Lordship.
Indisposed today. List on such and such. Yes.
Blush.
Your Lordship, item number 12 also on behalf of Inauli. Here, the affidavit has been sent for vetting, Your Lordship. So kindly let the matter come up after a week.
Learned government advocate, Miss AIME, prays that the matter may be listed after 1 week as the affidavit has been sent for vetting and awaiting the signature. Stop. Learned counsel for the petitioner, Mr. Pendang Wapang is present. And there's no objections, list after 1 week.
Much.
Yes.
Much I beg to mention item number 23 for hearing. Basically, we're seeking for payment of compensation in terms of the Act of 2013, whereas the state has filed an appeal as to the applicability of this act.
Yes.
If it may be
Pending.
yeah, if it may be
Learned
for 3 weeks.
Yes, learned counsel for the petitioner, Mr. Mo Jamir, submits that a similar matter is pending before the division bench and therefore prays that the matter may be listed after 3 weeks. 3 weeks. So list after 3 weeks as prayed.
Lordship, may I beg to mention item 9. I'm appearing on behalf of leading counsel Zakato Chishi. He has some personal difficulties today, so kindly pass over the matter tomorrow.
Learned counsel, Mr. Zakato Chishi makes a mention on behalf. No, you are Mukoka. Makes a mention on behalf of the leading counsel, Mr. Zakato Chishi, who has some difficulties today, to pass over the matter for the day. So pass over for the day. Yes.
May I please, Lordship?
Yes.
Lordship, I beg to mention item number 17. Lordship, I have received a copy of the affidavit filed by the government 1, 2, and 3 respondent. May be allowed 3 weeks time to reply on that.
Learned counsel for the petitioner, Mr. W.R. Muli, prays for 3 weeks' time to file a reply to the affidavit in opposition filed by the respondents. Stop. Accordingly, list the matter after 3 weeks. Yes.
Much obliged.
Yeah, please, Your Lordship. Your Lordship, I beg to mention item number 18. Kindly pass over the matter for tomorrow as my senior counsel is indisposed.
May I please, Lordship? Yes. Lordship, the address of respondent number 5 could not be traced. So if we may be kindly allowed to take substitute notice. Respondent 5.
Okay. Learned counsel for the applicant, no? Learned counsel for the applicant, Ms. Surgeon Such, submits that the address of the respondent number 5 could not be traced out, and therefore she prays that they may be allowed to take steps by substituted summon on respondent number 5. So the prayer is allowed. The petitioner the applicant shall take steps and thereafter file the compliance affidavit along with the newspaper clipping. So list after 4 weeks. Learned counsel, Ms. Such and Such appears for the respondents. Okay. Renboni, no?
Yes, Your Lordship.
Appears for the Respondent 1 to 4. Yes.
May I please, Your Lordship? My lord, I beg to mention item number 3. Here, I have received the affidavit in opposition filed by the state as well as the private respondent. So allow me 1 week time to file affidavit in reply to both the affidavit filed by the state as well as the private respondents.
Learned counsel for the petitioner, Mr. Takakichu, submits that he has received the affidavit in opposition of the state respondents as well as the private respondents, and he wishes to file a reply to the same. And he wishes to file replies to the same and prays for 1 week.
1 week.
Time stop. List after 1 week as prayed. Mr. N. Mosui and Ms. S. Chang, respondents.
Obligation.
Yes.
Wait, this Your Lordship. I beg to mention hearing item number 26 and 27. Ensuring on behalf of Advocate Rajiv R. Raj, counsel for the petitioner,
Yes.
he has personal difficulty today.
Okay.
I pray that this matter may be fixed on 12th of May.
Learned counsel, Ms. Manu Seno, appearing on behalf of the petitioner, submits that the leading counsel, Mr. Eli Ralu, has difficulty.
Rajiv R. Raj.
Oh, Rajiv
R.
R.
Raj.
Raj has difficulties to appear today and prays for listing the matter on
12th May.
12th May. Stop. Who are appearing for the
Lordship,
response?
appearing for respondent 1 on behalf of my senior, Mr. Akhil Jusi, who is the standing counsel for the respondent 1.
Okay. Learned counsel, Ms. Sindal Longkamer, submits that the leading counsel, he is also not present.
Yes, Lordship.
The counsel, Mr.
Akhil
Akhil
Jusi.
Chuse, is also having difficulties today. So accordingly, list the matter on 12th May as prayed for.
Lordship, interim in both the matters.
The interim orders passed earlier shall continue till the next day in both the cases. Huh? Yes.
Yes, may I please, Your Lordship? I beg to mention item number 8. I have received a affidavit in opposition filed by the Union of India on 16th of April. So I pray I may be given 2 weeks' time to file my reply.
Learned counsel, Mr. Sentilong submits for the petitioner. Sentilong submits that he has received a copy of the affidavit in opposition from the Union of India. Stop and prays for 2 weeks' time to file a reply to the same. What about state filed?
Status already for this.
The list after 2 weeks as prayed.
Much obliged.
Lordship, I'd like to mention item number 13, Lordship.
13.
2 weeks' time if granted to me, Lordship.
To file affidavit?
Yes, Lordship.
So learned counsel for learned government advocate, Ms. S. Chang, prays for 2 weeks' time to file affidavit in opposition. Stop. Learned counsel for the petitioner is present and there's no objections. List after 2 weeks. Yes.
So, Lordship, I beg to mention item number 6.
Yes.
Since my senior is facing some personal difficulties, that this matter will be fixed on Thursday. 6.
Item 6. Learned counsel, Mr. Sarin Such, prays that the matter may be listed on 23/4 as his senior is having some difficulties today. So list on Sarin Such. Yes, Thursday.
Similar prayer for item number 24.
Hearing.
Yes.
24 also, same. Thursday.
Thursday. Next week, Thursday. Much obliged.
Your Lordship.
Yes.
Lordship, I'd like to mention item number 25. Kindly pass this over for the day, Lordship.
Learned counsel, Ms. Such and Such for the petitioner, prays for passing over the matter for the day. So pass over. Yes.
Much obliged.
My humble apology, my lord. My lord, in item number 7, there is an interim, Lordship. May we please to continue the interim.
In 17?
In 17, Lordship.
Okay. 17, huh? The interim order passed earlier shall continue till the next day. Yes.
Humble apology. Let's go.
For motion from the supplementary cost list, item number 28.
This
Yes.
I'll take your lordship to Annex G.
Page 64, the operative portion is at page 67. Paragraph 13 and 14,
Yes.
if I may read. Now the question arises as to whether the petitioner is entitled to receive the pay scale at par with state secretariat employees in view of the admitted fact that the office of the Advocate General Nagaland is equivalent to the Secretary of the State of Nagaland. This question has not been decided by the respondent state. Therefore, it is directed that if the office of the Advocate General is equivalent to the office of a Secretary of the State of Nagaland, the state shall decide whether the employees of the establishment of the office of the Advocate General Nagaland are entitled to the pay scale of Secretariat employees pay scale. The state respondents shall pass speaking order to that effect. So the petitioner was serving as a UTA at the office of the Advocate General at Gauhati.
Okay.
So that, yes, so the Advocate General had also written to the state that since it is the
No,
office-
but what about the employees here? They'll all receive the same scale. The
Eh,
employee,
it-
the
it
Advocate
varies.
General's office here.
It varies. I have also made specific statements and records are there here. So my only limited question is this was the decision of this honorable court that it is admitted that the Advocate General, the office of the Advocate General is equivalent to the Secretary. So now the question is, if it is so, then the employees also.
So after this, have they passed
after
any
this-
order?
Yes, after
That's-
this, they passed an order which I am aggrieved with, which is at annexure is page 74. Now, this was peremptorily passed without referring the matter to the finance department and the PNR department. They have reflected the PNR department's letters and all, but it is prior to the judgment. That's your lordship will say.
Since the entry. They have also passed this
Yes.
in pursuance of a finance department noting. Finance department.
2019 and
2017.
2017, but this judgment was passed on 2024, on 25/4/2024, as your lordship may see here.
24.
So it is to be independently taken up before the.
No, but the position may not have changed because they said unless in the coming future the entry level recruitment and cadre management are processed at par with the Nagaland Secretariat Service, such and such, the office of the Advocate General shall remain the same as it is.
Your lordship, that is what they are saying, but it is an admitted fact that the office of the Advocate General is at secretariat level. The judgment is very clear. Now the only question is to decide. Now
It was admitted by the respondents in the previous petition.
This is why the judgment is very clear. Your lordship, the paragraph 13.
Okay.
Paragraph
Should
13.
notice.
Yes.
Yes, any idea what whether they are receiving district scale or the directorate scale, even the employees here?
The petitioner, his rank will be, he will get governed by the directorate, not by the secretariat service rules.
Maybe we'll see. Yeah.
Yes. My case is very limited. They ought to have separated to the government.
Subsequent to this order, the petitioner has filed another repetition. I think in that case, the issue has been discussed. But then today, I don't have that relevant judgment. So
Okay.
we will have to check out that order. Yeah, subsequent to this order.
Subsequent to this court's order.
Yes.
So another petition.
Yes, another petition was filed by the petitioner. Different counsel.
Okay.
Yes.
The instant application under Article 226 of the Constitution of India has been preferred by the petitioner, praying for grant of Secretariat pay scale to the petitioner in the pay band of level 14 of the Nagaland Services ROP 2017. Stop. Para Learned Counsel for the petitioner, Mr. Tongpuk Pongoner. Stop. The petitioner has placed reliance on the order dated 25/4/2024 passed in WPC 131/2023, wherein this court had observed that it is an admitted fact that the office of the Advocate General Nagaland is equivalent to the Secretary of the State of Nagaland. Stop. Accordingly, it was directed that if the office of the Advocate General is equivalent to the office of a Secretary of the State of Nagaland, the state shall decide whether the employees of the establishment of the office of the Advocate General Nagaland are entitled to the pay scale of Secretariat employees pay scale. And the respondents were therefore directed to pass a speaking order to that effect. So, thereafter, the
Annexure S, page 74.
Thereafter, the Secretary to the Government of Nagaland, Department of Law and Justice, issued the impugn order dated November 2024, by which it was held that the petitioner was appointed in the pay scale of district level LDA and cannot be granted the Secretariat pay scale of level 14 as requested by him. The said order dated November 2024 was based on the advice of the Finance Department, Vite U.O. number 243, dated 26/6/2017. So the petitioner, the Learned Counsel for the petitioner states that the advice of the Finance Department was prior to the disposal of the WPC, what did I say? WPC 131 of 2023, and hence the Department of Law and Justice had to the Department of Law and Justice should have processed the application of the petitioner to the Finance Department for its advice afresh.
On the basis of the order.
Afresh on the basis of the order dated 25/4/2024 in WPC 131 of 2023, which was not done. Stop. Hence, the petitioner has come before this court. So, issue notice returnable in 4 weeks. Learned Senior Government Advocate Ms. S. Mary accepts notice on behalf of all the respondents. Hence, no formal notice is called for. So, the Learned Counsel for the petitioner shall serve extra copies of the petition on the Learned Government Advocate during the course of the day. So, please, after 4 weeks.
Right.
For motion, item number 29.
Yes, Mr. Lordship.
Yes.
Your Lordship, here in this present petition, the petitioner is seeking for compassionate appointment. The petitioner late husband was serving as a constable under the Director of General Police in Changbunya. And after serving for 24 years, he died in harness on 9/05/2023. And after the petitioner submitted an application dated 1/09/2023. However, on non-consideration of that application, the petitioner submitted another reminder application on 5/12/2025. However, the petitioner yet to consider the both the representation of the petitioner.
You'll have to see where you figure in the list, compassionate appointment list. You'll issue notice. the instant application has been preferred by the petitioner seeking a writ of mandamus directing the respondent authorities to consider the petitioner's case and to appoint her on compassionate ground in terms of the office memorandum number AR-8/8/78 dated 17/9/2015. So, her learned counsel for the petitioner, Miss
Shisa Jamil.
Shisa Jamil. So, it is the case of the petitioner that the petitioner's husband died in harness on 9/5/2023, leaving behind the petitioner and 2 minor children with no earning member in the family. Stop. The petitioner had submitted an application dated 1/9/2023 seeking compassionate appointment. Stop. However, the same was not considered. Stop. Thereafter, a reminder application dated 5/12/2025 was also submitted. Stop. However, the respondents have not taken any action till date. Stop. Being aggrieved, the petitioner has come before this court. Stop. Issue notice returnable in 4 weeks. Learned Government Advocate Mr. M. Longkamar accepts notice on behalf of all the respondents. Hence, no formal notice is called for. So, learned counsel for the petitioner shall serve extra copies of the writ petition on the learned Government Advocate during the course of the day. Please stop the forms.
For admission, item number 1.
Please allow.
Yes.
Lordship, this is the second round of litigation. Earlier,
This is regarding that ACR grading.
Lordship,
You're ready? You want to hear? This
yes,
is
Lordship.
counter filed.
Yes, Lordship. Pleadings are filed.
Okay. You have filed a recast petition.
Lordship. Because on earlier question, Lordship, you could find that there's some frequencies in the pagination. So.
Yes, I remember. And then your annexed chairs were all ineligible. We could not read it.
Now,
You have replaced.
yes.
Okay, yes.
Lordship, I think, Lordship, that this is the second round of litigation. Earlier, litigation was disposed of with the direction to the respondent considered by representation. And earlier order is Lordship is at page.
Page.
Lordship. Annexure page 83, Lordship.
80.
83.
83.
Operative part is at page 87, paragraph 12. In view of the reason stated above, the respondent number 2, 3, and 4 are directed to take a decision as to which authority higher than the authority who gave the gradings in the excess efforts for the year so and so is to examine and take a decision on the petitioner's representation dated so and so and so. Thereafter, the chosen authority should decide the petitioner's representation. The entire exercise should be concluded within a period of 3 weeks from the date of receipt of a certified copy of this order. The decision taken by the authority should be communicated to the petitioner thereafter. So, Lordship, thereafter, the respondent has disposed of my representations on 29 January 2024.
Avno, you can come later. 1 minute. Yes, then
Therefore, Lordship,
direction
respondent has,
dispose.
disposed my representation by speaking order dated 29/1/2024, annexure P, and the type copy is at page 92.
Page 92. Yes.
Lordship, the operative part is at page 94. Paragraph 7. Now, therefore, in the light of the facts and circumstances emanated in the preceding paragraph, the competent authority of the skill examination of the representation of the petitioner dated so is of the considered opinion that the request of the petitioner to update his ACR APA awarded to him by his reporting officers filled on the basis of the performance during the respective professional years lacks merit, therefore is filed. So here I am impugning this speaking order. And also I'm impugning the and also I'm impugning my ACR for the period 2019 and 2022.
2019 and 2022.
I'm impugning.
2019 and 2022.
I'm just 2019 to 2020 and 2021 to 2020.
2021 to 2022. 2019 to 2020 and 2021 to 2022.
And Lordship, the adverse entries which was awarded to me was solely based on my action as a whistleblower and my legitimate insistence on proper medical examination. And same has been acknowledged by the Honorable Manipur High Court. I will come to later, Lordship. And it's a settled law that if the court finds that the adverse entries in the ACR made purely on extraneous consideration, then the court must interfere and quash those entries.
What did you say the grounds were? Because you were a whistleblower, and secondly,
yes, I was because I acted as a whistleblower and I have insisted on proper medical examination.
Insisted on proper medical examination.
Yes. So, Lordship, as it is settled law, that if the court finds that the entries which is made on extraneous consideration, then the court can interfere and quash them. So, Lordship, I rely on some decisions. I prepared a compilation of the judgment as well as I've given the list of citations. Lordship, firstly, I rely on the decision of the Honorable Delhi High Court. Lordship, kindly come to page 9 of my
Yes,
citation.
Amit Nehra.
Yes, Lordship. Amit Nehra versus page 9, paragraph 24. Lordship, I am allowed to read. In Rajendra Singh Sarwat versus Union of India, the petitioner had challenged to the adverse entries in his essay in the year 1995 to 1996. One of the grounds on which it was challenged was that the respondent number 3, the reporting officer, and respondent number 4, the reviewing officer, were biased against the petitioner on facts while acting with the petitioner. The court observed the officer writing the confidential report should show objectivity, impartiality, and fair assessment without any prejudices whatsoever, with the highest sense of responsibility to inculcate devotion to duty, honesty, and integrity to improve excellence of the individual officer employee. It is the duty of the reporting officer and the reviewing officer to take care not only that in the assessment of overall performance of subordinate employee or officer, they are not influenced by any personal interest, bias, or malice, but to avoid appearance of laboring under such influence. In other words, it must appear on the face of the record that in assessing overall performance of giving grace to an officer in his SAR, the authorities had acted fairly and without any bias in fact. Also, kindly come to page 10, paragraph number 26. In similar circumstances, in his decision dated so-and-so, this court in similar circumstances held that where there was likelihood that the third respondent had reason to explain anonymously and bias against the petitioner, the adverse entries were directed. In a decision dated so-and-so, in WPC number so-and-so, Vivek Srivastava versus Union of India, the challenge was to the adverse entries in the SAR of the petitioner while setting aside an adverse remarks. The respondents were directed by the court to consider the case of the petitioner for promotion uninfluenced by the recording of adverse remarks in the SAR for the period concerned. Now, Lordship, I rely on one decision of the Punjab High Court, Punjab and Haryana High Court. Lordship, kindly come to page. The party's name is Divanchal versus Punjab and Haryana High Court. Lordship, kindly come to page 16. Lordship, it's my mistake. Page 18. Page 18. I have highlighted the operative part, Lordship. Page 18.
Yes.
I have highlighted in Abbas's case, it is noted that if adverse remarks relating in integrity are found casual, pre-functionary, or cryptic, or where it is found that adverse remarks have been made for extraneous consideration or there is non-application of mind, the court will have to scrutinize the challenge to such remarks with greater seriousness. The remarks have been made without any material being available. Now, Lordship, I rely on one decision of the Rajasthan High Court. Lordship, kindly come to page 23. Page 23.
Yes.
Paragraph number 7. At the outset, it is made clear that this court cannot moderate the appraisal and grading given to an officer employee while exercising power of judicial review. Court should not venture to assess and appraise on the grading of an employee. But if the court finds that adverse entries made in the SAR or grading given to an employee are vitiated by extraneous consideration, the court must interfere and quash them. It is essential to maintain the integrity and sanctity of the SAR of an employee and the legitimacy of the conclusions relating to his or her overall performance. The object of writing confidential reports or character of role of a government servant is to afford an opportunity to the officer concerned to remove his deficiencies, if any, to inculcate discipline and to improve quality, excellence, and efficiency of public service. The officer writing the confidential report should show objectivity, impartiality, and fair assessment without any prejudices whatsoever, with the highest sense of responsibility to inculcate devotion to duty, honesty, and integrity to improve excellence of an individual officer. Thus, the action of the officer entrusted with the duty to write SAR must not be susceptible to the rise of arbitrariness. It is the duty of the reporting officer and reviewing officer to take care not only that their assessment of overall performance of the subordinate officer, but also they are not influenced by any personal interest, bias, or malice. In other words, it must appear on the face of the record that in assessing overall performance and giving grade to an officer in his SAR, the authorities have acted fairly and without any bias. Lordship, from paragraph 10, 11, 12, 13, and 15 are important in this regard, Lordship.
No, see, Learned Counsel, the fact that there should be no extraneous considerations in the ACR reading, that is not disputed. That is settled law.
Yes.
But each case will depend on its own facts and circumstances.
That's why, Lordship,
So in this particular case, you have to show what is that malice or what is the extraneous consideration.
Lordship. Lordship, I will be relying on only last citation of the Honorable Supreme Court, Lordship, regarding this extraneous consideration. That is page, Lordship, page 30. The parties name are S. Ramachandra Raju versus State of Orissa, AR 1995, SC 111. Lordship, paragraph 11, page 30, I have highlighted the important part. This case would establish as a stark reality that writing confidential reports bears onerous responsibility on the reporting officer to eschew his subjectivity and personal prejudices or proclivity or predilections and to make objective assessment. It is needless to emphasize that the career prospect of a subordinate officer employee largely depends upon the work and character assessment by the reporting officer. The latter should adopt fair, objective, dispassionate, and constructive comments in estimating or assessing the character, ability, and integrity and responsibility displayed by the concerned officer employee during the relevant period for the above objective, if not strictly adhered to in making an honest assessment. The prospect and career of the subordinate officer being put to jeopardy, the reporting officer is bound to lose his credibility in the eyes of his subordinates and fail to command in respect and work for them. The constitutional statutory safeguards given to the government employees largely became responsible to display callousness and disregard of the discharge of their duties and make it impossible to the superior or controlling officers to extract legitimate work for them. The writing of the confidential is contributing to make the subordinates work at least to some extent. Therefore, writing the confidential reports objectively and constructively and communication thereof at the earliest and would pave way for MS by adding subordinate officer or to improve the efficiency in service. At the same time, the subordinate employee officer should dedicate to do hard work and duty assiduity in the discharge of the duty honestly with integrity in performance thereof, which alone would earn his usefulness in retention of service. Both would contribute to improved excellence in service. Lordship, therefore, Lordship, with regard to this instant case, Lordship,
Yes.
so Lordship, I will take you, Lordship, to the backdrop of this instant case. What exactly happened, Lordship? Which is leading to the getting me as an adversary. Lordship, it happened, I was posted in Tripura. Then some of the staff was illegally selling CST items. Then I have objected. On my objection, they have formed tentative charges. 2 tentative charge sheet was leveled against me, Lordship, because I have raised objection against this illegal selling of CST items. However, Lordship, this charge sheet I have input before the Honorable Manipur High Court, and the same is pending for adjudication. Secondly, what happened, Lordship? The respondent number 5, who is my
What happened? You raised
same is pending.
you raised objection regarding the selling of the CST items.
CST. And then thereafter they have framed charge sheet against me. The respondent.
Departmental proceedings.
Yes. And the same being agreed by this charge sheet, I prefer
because you complained.
Yes.
Departmental proceedings were drawn up against you.
Yes, Lordship. I have stated in my petition categorically, Lordship. Kindly come to page 6, para 4. Para 4. That it is pertinent to mention that when the petitioner was posted at 38 Assam Rifles at Telimura, Tripura, he was deputed at the official canteen for about 1 month for the distribution of CST items, ration items, and liquor under the command of the then 38 Assam Rifles, namely G.B. Raghavan. However, the concerned staffs have illegally sold the CST items and ration to the civilians, and consequently, the petitioner made a complaint to the Chief of Army, Government of India, and the complaint of the petitioner was registered with the grievance cell with ID number so. Thereafter, the said proceeding of the staff court of inquiry was completed in the month of September 2018. In this regard, the Colonel Director so communicated to the Director General of Assam Rifles by writing a letter number so. Thereafter, a staff of inquiry was constituted for asserting the allegation made by the petitioner against Colonel so-and-so, former commandant of 38th Assam Rifle. In this regard, the respondent number 2 issued a convening order number so-and-so, so-and-so. That thereafter, very unfortunately and surprisingly, the petitioner was charged tentative charge sheet dated so-and-so, which was never committed by him. Being aggrieved by the said act of the respondents, the petitioner approached the Honorable High Court of Manipur by way of filing WPC number so-and-so, praying for quashing the tentative charge sheet dated so-and-so, framed against the petitioner along with some other relief. And the same is still pending for adjudication before the Honorable Manipur High Court. Now, Lordship, the respondent number 5, who is my reviewing officer, he has instructed me to withdraw the said petition. And I, as usual, Lordship, I have declined to follow his instruction. Then he got very much angry with me. He was very much annoyed with me because I have not withdrawn the said petition. And in the meantime, Lordship, I was transferred from 18 Assam Rifle. And that transfer order was also not compliant. They have forcefully detained me in the same unit, Lordship, 18 Assam Rifle. However, Lordship, after the issuance of the...
Then you filed another WP to release you.
Sorry, Lordship?
You filed another writ petition.
Yes, Lordship. Yes, Lordship. I filed. So, Lordship, thereafter, after some days, that is after the issuance of the transfer order, I mean some months, Lordship, I went to the unit hospital.
494, 2020. Okay, then?
I went to the unit hospital for regular checkup. However, respondent number 7 has directed me to take admission on the ground that in the hospital, take admission in the hospital on the ground that my health, there is a blockage in my heart as per the medical and ECG report conducted on 23/4/2020. I visited on 27/4/2020 the unit hospital, and the respondent number 7 has suggested me that there is a blockage in my heart as per the medical report conducted on 23/4/2020. Therefore, Lordship, when I was having a doubt, because I was okay, my health condition was absolutely okay. So I was having a doubt about the conduct or the direction of the respondent number 7. Then I have just requested that I may be allowed to go to some other super specialty hospital to confirm, to verify whether what is the finding of the medical report of 23/4/2020, it was okay or not. At this, Lordship, the respondent number 7 got annoyed, and that is the respondent number 7, has prepared one medical advice certificate. She has drafted by herself, and she has directed me to put my signature. That is, Lordship, page 40. Page 40 is the translated copy. This has been drafted, written by respondent number 7. It was not written by me. I may be allowed to read.
Yes.
I, Rajiv Kumar Sarkar, so went to MI room for AME on 27 April 2020. During checkup, my blood pressure was found to be high and ECG was also bad. The unit doctor told me after talking with IGR so-and-so medical specialist that in medical specialist opinion, I should be admitted in the hospital monitored, but I did not accept the opinion and by my own choice did not want to be admitted. Company commander, sir, also told me to get admitted in the hospital, but I did not take his advice. I did not get admitted. If I face any problem in future due to my illness or accident happens to me, then it will not be better than doctors and medical staff or anyone else will not be held responsible for it. I myself will be responsible for it. The respondent number 7 has filed a false complaint against me. And the copy was never given to me, and it has been included in the counter affidavit of the respondent. That is annexure 3. Annexure 3, page 23. It is intimated that number JC so of this unit, who has been admitted in unit hospital with effect from 10 May 2020 for his 6-hour hourly BP monitoring was as advised by medical specialist IGS so has threatened and misbehaved with understand at around 12:20 hours today. The matter has been informed telephonically to adjudicate at around 12:35 hours today. While taking what rounds, the undersigned has asked the above mentioned JCO about his well-being. Then he started accusing that he has been intentionally admitted in the unit hospital by the undersigned. He also mentioned that the details endorsed in his case sheet are wrong. His reports are normal and he does not need any kind of monitoring. During the convention, he also commented, Madam, I am not born after eating Amul milk and like you, I have served at high altitude area and I am not weak. Thereafter, the undersigned had advised him to give in writing about all his complaints rather than unnecessarily arguing. Then he started threatening the undersigned by saying, Madam, I will see you later and given in writing to whom I want to. Moreover, he sometimes puts pressure on paramedical staff to check his BP repeatedly and orders them to endorse lesser and false reading of BP in his case sheet. However, Lordship, in the medical certificate, which was drafted by the respondent number 7, she has not stated anything. Even the last line also she has not stated. Now she has twisted in her complaint letters and filed a false and malicious complaint against me. Consequently, Lordship, a show cause notice was given to me.
This complaint is by respondent 7.
Yes, Lordship. So on the basis of that complaint, a notice was served, show cause was given, show cause notice was given to me. That is annexure C, page 41. The first show cause notice was given on
Page 41.
41 annexure C.
Yes, what does it say?
First notice was given on 28 April 2020, and second was given on 29 April 2020. That is Annexure D, page 40.
One was 28 April.
28 April
The other one
2020,
is
and next was, that's a reminder, 29 April 2020. Without affording any reasonable time lordship to me to give my reply. So they have not given any reasonable opportunity also, lordship, to me to comply with the short course lordship, which is purely violation of.
So finally, did you reply? Did you submit?
No, lordship, I have not replied.
No.
No, I have not replied. Before I reply, they have instituted court of inquiry against me. I will come later on this aspect. Lordship, regarding this, lordship, I rely on one decision of the Honorable Supreme Court, lordship, that they have violated the principle of natural justice of my citation, lordship, AIR 1967, SC 1269, page 34, lordship. Page 34, paragraph 12. I have highlighted. It is true that the order is administrative in nature, but even in administrative order, which involves civil consequences, as already stated, must be made consequently with the rules of natural justice after informing the respondent of the case of the state, the evidence in support thereof, after giving an opinion to the first respondent of being heard and meeting or explaining the evidence. No such steps were admittedly taken. The High Court was, in our judgment, right in setting aside the order of the state. Here, lordship, no opportunity was given to me. Sufficient, no affordable opportunity. Just within 1 day, lordship, I have to reply to their shockers. Besides, lordship, the complaint letter was also never furnished to me. The discharge certificate, it was prepared by the respondent number 7, whereas in the complaint letter, she has crafted like anything. She has not stated anything in the discharge certificate.
The show cause says you are therefore requested to submit your reply
Yes,
to this show cause within 24 hours.
lordship, not sufficient opportunity, lordship. Therefore, lordship, on 2nd May 2020, that is annexure E, page 43. I was directed to return all the classified document to my junior, lordship. To my junior, not my senior also. And the subject is disobedience of lawful command given by a superior officer. 2nd May, lordship. No, show cause notice was given on 29 April and 2nd May.
This page 43 is, what is this?
Lordship, by this letter, they have directed, the respondents have directed me to hand over all the classified documents to my junior officer.
Then after that.
Now, lordship, lordship, kindly come to page 50. Page 50, it is a typed copy of the medical report. Lordship, here it is written, the patient denies any symptoms, no HS so-and-so cardiac involvement, no significant family history, nothing, lordship, nothing. And that has been found on 8/5/2020. 8/5/2020. And the respondent number 7 in her discharge certificate, that is 27 April 2000, 7 April 2020, has stated that there is a problem and blockage in my heart. On 4th June 2020,
No, in this page 50 medical report,
Lordship,
it says serving such and such
There is-
hypertension detected during AME and high cholesterol level also.
page 50, Lordship.
Page 50,
Yes, yes.
you were referring to page 50.
Yes, Lordship.
So in this medical report,
Other
it
after
says
this
that
high cholesterol level,
you have
patient denies any symptom.
hypertension and high cholesterol. You have denied, but the
Yes.
medical report says that you have hypertension and high cholesterol level.
High cholesterol, but there is no blockage. But the respondent number 7 has said that there is a blockage in my heart. There is saying no history cardiac involvement, Lordship. No significant family history. That is after a gap of 10 days. Within a gap of 10 days, my heart was okay.
Okay, then
Lordship, thereafter, Lordship, a court of inquiry was instituted against me. That is annexure G, page 46.
yes. Please read.
Lordship, so being agreed by this court of inquiry, Lordship, I have preferred a writ petition before the Honorable Manipur High Court. And the Honorable Manipur High Court was pleased to acknowledge all those malicious acts of the respondent. Lordship, kindly come
Where is
to
that?
page annexure A, page 31. Operative part is at page 35. Paragraph B. The findings of the Manipur High Court. Being
One
agreed
minute.
by this date notice, page 35. Operative part is page 35. Annexure 1,
Yes.
page 31. Operative part is at page 35, paragraph 3. Being agreed by the state notice for the composition of a court of inquiry against the petitioner's husband, the instant petition has been filed with the petitioner, questioning it on the inter alia grounds that all the aforesaid actions were taken by the respondent authorities in order to harass the petitioner's husband for the reasons that the said petition being WBC number so and so was filed by him, and that the behavior of the superior officers harassing their juniors in the workplace is against the rule of law and unconstitutional. The adjournments, that is the writ petition, Lordship, I have filed because of the illegal acts. They are selling those serious items, which is pending before the Honorable High Court of Manipur. The writ petition. Then, Lordship, kindly come to page.
So this is still pending.
Lordship, that writ petition is still pending. Regarding the first court of inquiry. Kindly come to page 36, paragraph 4. The averments made in the writ petition, if found to be true and correct, can be said to be serious once, but this court is not inclined to entertain the writ petition for the reason.
Wait,
that-
page.
Lordship, page 36, paragraph 4. Next page, Lordship. After page 35, next page.
No, right now you're reading from page 36, paragraph 3.
Yes.
Being aggrieved by such and such.
Yes.
Then after that,
Paragraph 4, Lordship.
the averments made in the
Yes,
petition.
The averments made in the writ petition, if found to be true and correct, can be said to be serious ones, but this court is not inclined to entertain the writ petition for the reasons that it was filed after 3 months from the date of notice of court of inquiry dated so-and-so, being issued directing the petitioner's husband to report to the presiding officer at KLP Modi on or before so-and-so. Failure on the part of the petitioner's husband to report to the presiding officer, a warning letter dated so-and-so was issued, directing him to report by 9/6/2020, failing which a disciplinary action would be initiated against him. No matter has been placed on record by the petitioner to show as to what happened thereafter pursuant to the said notice dated so-and-so. In the absence of any material to know what happened during the last 3 months, it may be appropriate for this court to entertain the writ petition and pass any order which might affect or have a bearing on the actions, if already taken by the respondent pursuant to the said notice. But it may be noted that the respondents, being the institutional authorities, ought to act fairly and reasonably. Any action taken by the respondents is found to be unreasonable, arbitrary, etc., will be rendered violative of Article 14 of the Constitution of India. In view of the above, this court is of the view that the ends of justice will meet if the petitioner's husband is granted an opportunity to submit a representation on the issue. The state petition stands accordingly disposed of with the direction that the petitioner's husband may submit a detailed representation.
Disposed, where you're saying is still pending. It is disposed.
No, Lordship. The
Accordingly-
petition number 27 of 2020, that is pending. This petition is
This is 494. This is disposed.
This is disposed. This is disposed.
Disposed of with the direction
Yes,
to file representation.
Lordship. The state petition stands accordingly disposed of with the direction the petitioner's husband may submit a detailed representation to the Director General Assam Rifle. The respondent number 2 had within a period of 2 weeks from today, either through email, WhatsApp, or by hand or by speed post, and in the event of such representation being submitted by the petitioner's husband, the Director General of Assam Rifles Shillong shall consider it and dispose of within a month from the date of receipt of the representation by issuing a reasoned speaking order. As the petitioner's husband is not permitted to move out of the camp as alleged in the writ petition, he shall be granted permission by the respondent number 3 to meet his advocate, or his advocate may be permitted to meet him in the camp so that the petitioner's husband may be able to submit his representation, if so advised in time. If the petitioner husband is agreed by such an order to be issued by the respondent number 2 as regards the representation, it is open to him to approach any appropriate forum for dismissal of his grievances. Any penal or coercive action, if not taken, if not already taken, shall not be taken against the petitioner's husband till the disposal of his representation. It is made clear that this order shall not preclude the respondents, and in particular the respondent number 3, from releasing the petitioner's husband to join his duties at the new place of posting at Agartala in terms of the transport order dated so-and-so. Lordship, there consequently, Lordship, I was transferred. They have withheld my transfer order also. After the intervention of the Honorable
you went to Agartala.
Lordship.
After this, you went to your new place of posting.
Lordship, I was transferred.
And representation also disposed.
No, till now it is pending with them. They have not disposed. However, Lordship, on 9/6/2020-21, an extract copy of the SAR was forwarded to me. That is page 63. Page 63. Page 63, annexure here. Lordship, kindly come to page 64. Extract of page 64. extract of adverse weak points in the pen picture by paras 15 to 16 of page number 4 of SCR for the period from 1 September 2019 to 31st August 2020 in respect of Rajiv Kumar Sarkar of Assam Rifles. Initiating officer has given me 0.4. Reviewing officer has given me.
So this 94 and 4, 93, 4.
This is Lordship serial number. This is their serial number. So they have not given the actual copy of the SCR. They have given me the extract. Whereas the rule is that they have to communicate me the details of each and every entry.
No, from here, how do you know that it is adverse?
Lordship, because Lordship.
No, is it like you just tell me how they calculate the grading? Because in our case, we give 1 to 10.
Yes,
1 to
similarly,
10, and
they're
then,
also giving 1.
and then they give fair, good, average, like that, huh?
Yes, yes. Same, Lordship, same. So they have given me these 4 points.
So out of this is out of 10.
Out of 10.
And what is this 92 and 93?
These are the serial numbers. Lordship, kindly come.
So this has nothing to do with the
No.
grading. So grading is 4.
4. They have given the detailed SCR. My SCR is at page 29 of their counter affidavit. They have not given me the details.
In the affidavit?
Page 29 is that. So this is also Lordship. It can be understood that 90 is the serial number. And grading they have given me is at page 32. Grading. Pen picture, confidential pen picture is written. So, Lordship, in the pen picture, they have made a remark which was not supplied to me when they have given me the extract copy of the SCR on 9 June 2021. I came to know only when they have filed their counter affidavit.
So you have been given average?
Lordship.
Average.
Lordship.
Yes.
So, Lordship, in the pen picture, the copy which they have given to me, it is nothing is there. But in the counter affidavit, they have make it details. Whereas the law it is a settled law that the respondents are duty bound to supply each and every details to the ratee. Besides, Lordship, there is a delay. There is a delay in preparing the SCR, supplying the SCR, both by the reviewing officer and by the initiating officer. That is respondent number 5 and 6.
Delay in?
Lordship, preparing the SCR. The SCR was, Lordship, the extract copy was given to me on 9/6/2021. And the SCR is for the period September 2019 to August 2020.
So extract copy of 19 to 20 was given when?
Yes, Lordship. And the SCR for that period was completed on August 2020. But they have prepared on 21st May 2020. there's a delay in Lordship. Regarding this delay, I rely on one decision of the Honorable Supreme Court. Lordship, kindly come to page 35 of my compilation of citations. Page 35 is the citation number is AIR 2020 SC 4661. Union of India and others versus GR McFarm. Kindly come to
This
page
is regarding delay.
delay, Lordship. Kindly come to page 37 of my compilation. And para 6.1. In the case of Devdut Supra, this court has held in paragraph 36 and 37 as under. In the present case, we are developing the principles of natural justice by holding that fairness and transparency in public administration requires that all entries, whether poor, fair, average, good, or very good, in the annual confidential report of a public servant, whether in civil, judicial, police, or any state service, must be communicated to him within a reasonable period so that he can make a representation for his application. This, in our opinion, is the correct legal position, even though there may be no rule or government order requiring communication of the entry, or even if there is a rule or government order prohibiting, because the principle of non-arbitrariness in state action, as envisaged by Article 14 of the Constitution, in our opinion, requires such communications. Article 14 will override all rules or government orders. We further hold that when the entry is communicated to him, the public servant should have a right to make a representation against the entry to the authority concerned, and the authority concerned must decide the representation in a fair manner and within a reasonable period. We also hold that representation must be decided by an authority higher than the one who gives the entry. Otherwise, the likelihood is that the representation will be summarily rejected without adequate consideration, as would be an appeal from Caesar to Caesar. All this would be conducive to fairness and transparency in public administration and would result in fairness to public servants. The state must be a model employer and must act fairly towards its employees. Only then would good governance be possible. Lordship, while taking a pause, I may be allowed to submit that firstly, the SCR which they have submitted, Lordship, which they have forwarded to me, they have not given me all the details. They have just informed me what was the grading I have received.
No.
On what ground, Lordship, the grading was given, nothing mentioned.
No need. Only the grading has to be communicated. No need to give all the
But Lordship, in
details.
the pen picture, it is empty. In the pen picture, it is empty. Nothing. Nothing is there, Lordship, in the pen picture. I came to know why I was graded 0.4 only when they have filed the counter affidavit. I was not knowing. And it is my right to know that
before that 2019 to 2020, what was the grading you were receiving earlier?
Lordship, because Lordship, for promotion, 5 years gradings is considered. So my 5 years starts from 2009. So before that, Lordship, I am not aware. I have not instruction. But I was due for promotion on 2022.
No, because if an officer is being graded very good throughout, then suddenly dropping down, that something suspicious is there.
That also I'll come.
So we have to know what were the gradings you were receiving earlier than that, earlier to 2019.
Actually, Lordship, what I'm trying to instruct on this honorable court is that for my promotion, the SCR is relevant from 2019 to 2020.
Yes.
So Lordship, that's why, Lordship, I'm not aware what was the grading.
Okay, and then?
Oh. And my instruction is that, Lordship, he was recommended, outstanding only. My instruction is that his before 2019, his grading was outstanding.
Okay.
Now, Lordship, kindly come to para 6.2 of the same case. In the instant case, the respondent was graded as very good in the SCRs for the years 2005 to 2006 and 2006 to 2007. However, in the year 2007 to 2008, he was graded only good, despite the fact that all years, the reporting and the reviewing officer were the same. In the case of debtor versus so-and-so, it was observed that all entries in the SCR of a public servant must be communicated to him within the reasonable period so that he can make a representation for his application despite there may be no rule or government order to that effect. Pursuant to the judgment in debtor supra, office memorandum dated so-and-so were issued by the appellant herein. The same are extracted as under. Worship, I'm just reading the operative part. The undersigned is directed to invite the attention of the Ministry's Department to the existing provisions in regard to the preparation and maintenance of annual confidential reports, which inter alia provide that only adverse remarks should be communicated to the officers reported upon for representation, if any. The Supreme Court has held in their judgment dated so-and-so in the case of Devdutt versus Union of India that the object of writing the confidential report and making entries is to give an opportunity to the public servant to improve the performance. The Second Administrative Reforms Commission in their 10th report has also recommended that the performance appraisal system for all services be made more consultative and transparent on the lines of the path of the all India services. Keeping in view the above position, the matters regarding communication of entries in the SCRs in the case of civil services under the Government of India has been further reviewed, and the understanding is directed to convey the following decisions of the government. The existing nomenclature of a SCR will be modified as a APAR. The full APAR, including the overall grade and assessment of integrity, shall be communicated to the concerned officer after the report is complete with the remarks of the reviewing officer and accepting objects. Wherever such system is in bed, where government servant has only one supervisory level above him, as in the case of personal staff attached to the officer, such communication shall be made after the reporting officer has completed the performance assessment. The section entrusted with the maintenance of APARs after its receipt shall disclose the same to the officer reported upon. The concerned officer shall be given the opportunity to make any representation against the entries, and the final grading given in the report within a period of 15 days from the date of receipt of the entries in the APAR. The representation shall be restricted to the specific factual observations contained in the report leading to the assessment of the officer in terms of attributes, work output, etc. While communicating the entries, it shall be made clear that in case no representation is received within the 15 days, it shall be deemed that he or she has no representation to make. If the concerned APAR section does not receive any information from the concerned officer on or before 15 days from the date of disclosure, the APAR will be treated as final. The new system of communicating the entries in the APAR shall be made applicable prospectively only with effect from the reporting period 2008-2009, which is to be initiated after 1st April 2009. The competent authority for considering adverse remarks under the existing instructions may consider representation if necessary in consultation with the reporting and or reviewing officer, and shall decide the matter objectively based on the material. Lordship, I'll take you to the next office memorandum. I'm just reading the operative part. The undersigned is directed to say that prior to the reporting period 2008-2009, only the adverse remarks in the SR had to be communicated to the concerned officer for representation, if any, to be considered by the competent authority. The question of treating the grading in the SR which is below the benchmark for next promotion has been considered in this department, and it has been decided that if an employee is to be considered for promotion in a future DPC, his SES period to the period 2008-2009, which would be reckonable for assessment of his fitness in such future DPCs, contain final grading which are below the mark for his next promotion. Before such SES are placed before the DPC, the concerned employee will be given a copy of the relevant SES for his representation, if any. Within 15 days of such communication, it may be noted that only below benchmark SR for the period relevant to promotion need to be sent. There is no need to send below the benchmark SRs. As per existing instruction, representation against the remarks for upgradation of the final grading given in the APAR should be examined by the competent authority in consultation, if necessary, with the reporting and reviewing officer, if any. While considering the representation, the competent authority decides the matter objectively in quasi-judicial manner on the basis of material laid before it. Lordship, while taking a pause, I'll submit that In this instant case, when the respondent has passed the impugned speaking order, there is no whisper that the respondent has, the respondent number 2 has consulted with the reviewing and the reporting officer. There is no whisper, there is no insistence, Lordship. Lordship, I may be allowed to
If
read
it only says if necessary, it
Lordship.
is not mandatory.
Lordship. This would imply that the competent authority shall take into consideration the contention of the officer who has represented against the particular remark reading in the APAR and the views of the reporting and reviewing officer if they are still in service on the points raised in the representation vis-a-vis the remarks gradings given by them in the APAR. The UPSC has informed this department that the commission has observed that while deciding such representations, the competent authority sometimes do not take into account the views of reporting review officers if they are still in service. The Commission has further observed that in a majority of such cases, the competent authority does not give specific reasons for updating the below benchmark ACR APAR grading at par with the benchmark for next promotion. Now, Lordship, kindly come to that next paragraph, that is on perusal. On perusal of OM dated 14/5/2009, it is noted that the new system of communicating and the entries in annual performance assessment report provides that the same should be communicated within a period of 15 days from the date of receipt of the entries in the APAR. The new system is applicable prospectively with effect from the reporting period 2008 to 2009, which is initiated after 1/4/2009. Further, as per OM dated 13/4/2010, it has been stated that the question of treating the grading in the SCR which is below the benchmark for next promotion has been considered by the department, and it has been decided that if an employee is to be considered for promotion in future DPC and his SCRs prior to the period 2008-2009, which would be reckonable for assessment of his fitness in such future DPCs contain final grading which are below the benchmark for his next promotion. Before such SCR are placed before the DPC, the concerned employee will given a copy of the relevant SCR of his representation, if any, within 15 days of such communication, and only below benchmark SCR for the period relevant to promotion need to be sent. There is no need to send below benchmark SCR of other years. So, Lordship, here, Lordship, as per the office memorandum of the issued by the Ministry of Personnel and Public Grievances and Pensions, the grading of the SCR should be communicated to me within 15 days. But it was not communicated to me.
Okay, then what else?
Yeah, Lordship, I'd like to address your Lordship. Your Lordship has raised queries that what was my grading before 2019. I have specifically mentioned in my petitions also, Lordship, very good. Para 23, Lordship. Para 23. Para 23, page 22. It is pertinent to mention that the aforesaid adverse gradings of the SCR FR was only given to the petitioner during the period when the respondent number 5 and 6 was the reporting officer and reviewing officer respectively. Whereas in the entire service career of the petitioner, no adverse grading in the SCR FR was given by any reporting officer and the reviewing officer. All along, except for the adverse SCR FR for the period 2019-2020 and 21-2021, 2020-2022, the petitioner has maintained very good grading in his SCR apart for his entire service. However, the respondent number 2 did not also consider this imperative aspect.
Okay.
And Lordship, I also would like to point out one relevant point, Lordship.
Hmm.
That is, can you come to page 32 of the council affidavit? Lordship?
Yes.
The ACR for the period 2019 to 2020 was supposed to be prepared within 20 itself, because it was till August. But they have prepared it on 21st May 2021, and the same was communicated to me on 9 June. And that is also, Lordship, not clearly they have mentioned why the grading was this 4. Then on what basis I could have made a proper representation? Though I have filed 2 representations being edited by the adverse grading in my essay. That is page 65 and page 66.
65 of the
representations.
writ petition.
Yes, Lordship. I have filed 2 representations against my adverse ACL grading.
Page 65.
Page 65
And the other one?
66, Lordship.
66.
Thereafter, I have received extra copy of the upper. This representation was disposed of by former that speaking order, MP speaking order. They have not considered it categorically. They have just as a whole, they have disposed my representations. Now, Lordship, on 28 December 2022, that is annexure M, page 67. Type copy is at page 68. Type copy is at page 68.
These 2 representations at page 65 and 66,
Lordship,
they were disposed of.
by speaking, impugn speaking orders.
The one which was issued after the writ petition.
Lordship, after the direction of
After the
public-
direction.
Yes.
Then
Then, Lordship, I have received my FR, that is annexure M, page 67.
67.
Type copy is at page 68. Here, Lordship, I was graded 5.5.
Where do we find that?
Lordship, kindly come to page 71.
71.
71
71.
and 72. And type copy is also there, Lordship. Type copy is at page and page 77. 77 and page 78, type copy.
This is for 21 to 22.
Yes, Lordship. Now, Lordship, kindly come to the pen picture. That is page 77 of my FR. Point number 17. The JCU is inefficient to carry out tasks assigned to him independently, the JCO needs remarkable improvement in his professional skills and attitude towards work. And in the next page, the pen picture of given by the reviewing officer. The JCO keeps his personal interest always above the organizational interest and liability on the organization. This is the they have.
So your prayer is to first and set aside that speaking order and
And the
to
advice-
upgrade the gradings.
Lordship.
Okay.
So, Lordship, if we cogently read the pen picture of both ACR and the APR, and Lordship, that is page 32 of the counter affidavit, the pen picture. And pen picture of ACR, and 77 is the pen picture of APR. So, Lordship, in the ACR, it is written an average JCO who need to improve upon his discipline, integrity, and professional conduct. Warning letter for the same was given to the JCO dated 8 June 2020. Lordship, this letter is under challenge before the Honorable Manipur High Court. And the initiating officer has based his remarks on this warning letter. Besides, before issuing this warning letter, I was not given any show cause loss. Court of inquiry is initiated against me. Thereafter, warning letter was given. Even the court of inquiry was not has not led to any conclusion. Thereafter, the warning letter was issued based on the complaint made by the respondent.
Court of inquiry is still going on.
No, Lordship, that has been stayed by the
Against that you have
yes, that has been stayed by the Honorable Manipur High Court, and the same is pending for its division. So, Lordship, regarding this, I rely on one decision of the Honorable Supreme Court.
In the compilation.
Lordship, yes, Lordship. So kindly come to page 66. Paragraph number page 66 is the name of the parties, and operative part is page 59, paragraph 11. On March 3, 1961, an office order was issued by the Commission which superseded all instructions issued previously on the subject matter of maintenance of confidential reports. This order applied to all officers of the Commission, gazetted and non-gazetted, and also its subordinate officers. The order was again resized the importance of preparing and maintaining confidential reports. Rule 4 requires that such a report should contain an appreciation of the general qualities of the government servants, such as integrity, intelligence, keenness, industry, tact, attitude towards his superior and subordinates, relations with fellow employees, work attitudes, etc., and also summing up in general terms of the government servants' good and bad qualities, and a categorization or rating such as outstanding, very good, good, fair, or poor. Such a categorization is, however, not necessary in the case of officers of or above the rank of superintending engineer. Rule 10 expressly provides that the reporting authority is not required to give any specific instances of his good or bad work or conduct upon which the opinion is based. Rule 28 provides that while communicating an adverse remark to the concerned government servant, the substance of such report and not its actual wording need to be conveyed. This is because the primary object of such communication is firstly that the concerned government servant may remedy his defects, and secondly that it serve as a timely warning to the government servant of such defects which might otherwise deprive him of chances of promotion in future. Rule 32 entitles a government servant to make a representation. Such representation would be examined by an officer in rank to the reviewing officer. That officer would either reject the representation or alter the remark where he thinks necessary, and in the event of his finding that remark is actuated by malice or is incorrect or unfounded, B would expunge it. Rule 34 provides that adverse centuries will take to any specific uh, incident will not ordinarily find place in the confidential record, but where a warning is issued as a result of any specific incident, a copy thereof would ordinarily be kept in the personal file of the government servant. In that case, he has to make a specific order to that effect. Before making such an order, he must give to the concerned government servant a reasonable opportunity to present his case relating to the incident. In case departmental proceedings are instituted as a result of such an incident and a formal punishment such as censure is awarded, a copy of the order of such punishment should invariably be placed in the confidential record of the government servant. These rules evidently show that the confidential report is intended to be general assessment of work performed by a government servant subordinate to the reporting authority, that such reports are maintained for the purpose of serving as data of comparative merit when questions of promotion, confirmation, etc. arise. They also show that such reports are not ordinarily to contain specific incidents upon which assessments are made, except in cases where, as a result of any specific incident, a censure or warning is issued, and when such warning is by an order to be kept in the personal file of the government servant. In such a case, the officer making the order has to give a reasonable opportunity to the government servant to present his case. The contention, therefore, that the adverse remarks did not contain specific instances and were therefore contrary to the rules cannot be sustained. Equally unsustainable is the corollary that because of that omission, the appellant could not make an adequate representation, and that therefore the confidential reports are vitiated. So, Lordship, the copy which was given to me, the Excel copy, there is nothing mentioned, Lordship. Nothing mentioned. So, as per this decision of the mandates of the Honorable Supreme Court, Lordship, the details should be given to me. Further, Lordship, kindly come to page.
No, it doesn't say it should be given to you. It only says that it should be kept in the personal file of the government servant.
Lordship is saying that the condition, therefore, that the adverse remarks did not contain specific instances.
Cannot be sustained.
Yes, Lordship. Cannot be sustained. So there is no specific instances, Lordship. Both in the APAR as well as in the SES.
No, that's why. The petitioner's contention that the adverse remarks did not contain specific instances, that contention cannot be sustained.
Lordship.
It says.
Lordship.
So why should they contain the specific substances instances? It should not. That can only be kept in the personal file. You read carefully. The contention that the adverse remarks did not contain specific instances cannot be sustained. So you're saying that the specific instances were not mentioned in the remarks, isn't it? So that it's not necessary. That has to be kept in the personal file only. It doesn't have to be reflected.
Lordship, kindly come to paragraph 30.
In fact, this is against you. Yes. What?
Further, the rules do not provide for require an opportunity to be heard before any adverse entry is made. The condition that an inquiry would be necessary before adverse entry is made suffers a misapprehension that such an entry amounts to penalty of censor set up rule 11 of the Central Civil Services. The entry is made under the office orders so set out above by way of annual assessment of the work done by the government servant and not by way of penalty under the said Central Civil Services. Two, it is that such remarks would be taken into consideration when a question such as that of promotion arises and when a competitive merits of person eligible for promotion arises. But then, whenever a government servant is aggrieved by an adverse entry, he has an opportunity of making a revision. Such a revision would be considered by higher authority if satisfied would either amend, correct, or even expunge a wrong entry so that it is not as if an active government servant is without remedy. Making an adverse entry is thus not equivalent to imposition of a penalty, and we should initiate an inquiry for the giving of a reasonable opportunity of being heard the concerned government. This apart, the appearance given therefore rejected. I have taken a wrong obligations. Nevertheless, Lordship, that part of my session may be expanded. Besides, Lordship, I rely on one decision, that is AR 1977. Your Lordship, kindly come to my compilation of software citation, that is page 42. Paragraph number 4. In S. Ramachandra Raju versus State of Odisha, so this court underlined the need to write confidential reports objectively, fairly, and dispassionately in a constructive manner, either commenting, downgrading the conduct, character, efficiency, or integrity of the officer in that behalf. It is stated in para 11 that from the year 1973-74, the performance of the duty by the appellant therein was consistently as satisfactory to fair, except for the year 1987-88, in which year he dropped down suddenly as an average or below average teacher. In that behalf, it was held that when he was a responsible teacher and he had cordial relation with the student community and was taking pains to impart lessons to these students, would it be believable that he averts to take classes and drops down, if not worst? When anterior to or subsequent to 1987 to 88, he was a man of ability and of integrity. The same whether would become below average only for the academic year 1987-88 without discernible reasons. It would speak volumes on the objectivity of assessment by the reporting officer, that is the principal. This conduct is much to be desired. This case would establish a stark reality that writing confidential reports bears onerous responsibility on the reporting officer to eschew his subjectivity and personal prejudices and proclivity and predelications and to make objective assessment. It is needless to emphasize that career prospects of a subordinate officer largely depends upon the work and character assessment by the reporting officer. The latter should adopt fair, objective, dispassionate, constructive comments in estimating or assessing the character, ability, integrity, and responsibility displayed by the officer employee concerned during the relevant period for the above objectives. If not strictly adhered to in making an honest assessment, the prospect and career of the subordinate officer being put to great jeopardy. The reporting officer is bound to lose his credibility in the eyes of his subordinates and fail to command respect and work for them. The constitutional and statutory safeguards given to the government employees largely became responsible to display callousness and disregard of the discharge of their duties and make it impossible to the superior or controlling officers to extract legitimate work from them. The writing of the confidential is contributing to make the subordinate works at least to some extent. Therefore, the writing confidential reports objectively and constructively and communication thereof at the earliest would pave way for amends by erring subordinate officer or to improve the efficiency in service. At the same time, the subordinate employee officer should dedicate to do hard work and duty as duty in the discharge of the duty. Honesty with integrity in performance thereof, which alone would earn his usefulness in retention of his service. Both would contribute to improve excellence in his service. In that case, on account of the vague remarks made for the year 1987-88, the appellant therein was compulsory retired from service. This court, after looking into the entire record, set aside the order. In Motiram Deka versus General Manager, a bench of judges had held that a modern democratic state, the efficiency and incorruptibility of public administration is of such importance that is essential to afford to civil servants adequate protection against capricious action from their superior authority. If a public servant is guilty of misconduct, he should no doubt be proceeded against promptly under the relevant disciplinary rules, subject of course to the protection under Article 311(2), but to maintain honesty, straightforwardness, and efficiency in permanent civil servants. It was pointed out from the point of view of the state that they should enjoy a sense of security which alone can make them independent and truly efficient. In Delhi Transport Corporation, so-and-so, to which one of us, K. Ramaswamy Justice, was a member, the Constitution Bench had held that the sword of domicils hanging over the head of a public servant would inevitably create a sense of insecurity. The unbridled, wide discretionary power would conceivably be abused. Thereby, this court laid emphasis that an assurance of security of service to a public employee is essential requisite for efficiency and incorruptibility of public administration. It is also an assurance to take independent drive and initiative in the discharge of public duties to actuate the goals of social justice set down in the Constitution. In paragraph 275 at page number so-and-so, it is further pointed out that court should take note of actualities of life that person actuated to corrupt practices are capable to maneuver with higher equations in diverse ways and also camouflage their activities by becoming psychopaths or cronies to the superior officer. Sincere, honest, and devoted subordinate officers are unlikely to leak the boards of the corrupt superior officer. They develop a sense of self-pride of their honesty, integrity, and empathy, and inertia towards corrupt and tend to undermine or show sign of disrespect and disregard towards the corrupt. Thereby, they not only become inconvenient to the corrupt officer, but also stand as an impediment to the ongoing smooth symphony of corruption at a grave risk at their prospect in career or even to their tenure of office. The term efficiency is an elusive and relative one to the adept, capable to be applied in diverse circumstances. If a superior officer develops leaking towards psychopath though corrupt, he would tolerate him and find him to be efficient and face encomious and corruption, and such case stand no impeachment. When he finds a sincere, devoted, and honest officer to be inconvenient, it is easy to cast her off by writing confidential reports with delightfully vague language, imputing to be not up to the mark, wanting public relations. At times, they may be termed to be security risks to their activities. Thus, they spoil the career of the honest, sincere, and devoted officer. Instances either way are gallored in this regard. Therefore, one would be circumspect, pragmatic, and realistic to these activities of life while engaging constitutional validity of wide, arbitrary, uncanalized, and unbridled discretionary power of dismissal vested in appropriate authority either by a statute or a statutory rule. Lordship, in my EPA, there is nothing mentioned, Lordship. It's written a liability on the organization. Similarly, here also the Honorable Supreme Court has made an observation, wanting public relation not up to the mark. Now, in what way and liability, nothing has been mentioned. Similarly. Now, Lordship, kindly come to paragraph.
Okay, basically you're saying that there is malice because the reporting officer, that is respondent number 7,
Yes.
had a personal bias against
Yes,
him.
Lordship. Because Lordship, even Lordship, I have filed a case also against them in the Honorable, before the Honorable High Court of Manipur.
So, who was the reporting officer? This respondent 7.
Yes, Lordship.
Then reviewing
Respondent number
officer?
5 and 6.
Okay, 5 is the reporting
Reporting officer.
and reviewing
Lordship,
respondent
I'm just-
6.
basically, 5 is the review officer, reviewing officer. And 6 is the initiating.
1 minute, 1 minute.
Reporting officer.
R5 is
5 is review officer, reviewing of or reviewing authority,
reviewing authority, and then
and 6 is initiating officer or reporting.
R6 is initiating or reporting.
Yes, Lordship. Because in the apart they said reporting officer, in the ACR they said initiating officer.
Okay.
Now, Lordship, kindly come to paragraph 5 of the same citation, page 44. In State Bank of India versus Kashinath K, in paragraph 15, this court pointed out that the object of writing the confidential report is twofold. That is to give an opportunity to the officer to remove deficiencies and to inculcate discipline. Secondly, it seeks to serve improvement of quality and excellence and efficiency of public services. This court in Delhi Transport Corporation.
No, these are all the principles.
Lordship.
Principles are clear.
Lordship.
You need not.
Lordship, that is
the only thing
one paragraph is very much
yes.
important. That is paragraph 7. Lordship, I may be allowed to read paragraph 7.
Page 44.
Yeah, page 45, paragraph 7. I may be allowed to read.
Yes. It
would thus be clear that the object of writing the confidential reports and making an entries in the character roles is to give an opportunity to a public servant to improve excellence. Article 51AJ enters upon every citizen the primary duty to constantly endeavor to prove excellence individually and collectively as a member of the group given an opportunity. Given an opportunity, the individual employee strives to improve excellence and thereby efficiency of administration would be augmented. The officer entrusted with the duty to write confidential reports has a public responsibility and trust to write the confidential reports objectively, fairly, and dispassionately while giving as accurately as possible. The statement of facts on an overall assessment of the performance of the subordinate officer, it should be founded upon the facts or circumstances, though sometimes it may not be part of record, but the conduct, reputation, and character acquire public knowledge or notoriety and may be within his knowledge. Before forming an opinion to be adverse, the reporting officer writing confidential should share the information which is not a part of the record with the officer concerned, have the information confronted by the officer, and then make it a part of the record. Your Lordship, nothing has been made. Nothing was done, Lordship, by the respondent number 5 and 6. Lordship, I will have to continue to read. This amounts to an opportunity given to the erring corrupt officer to correct the errors of judgment, conduct, behavior, integrity, or conduct corrupt proclivity. If despite giving such an opportunity, the officer fails to perform the duty, correct his conduct or improve himself necessarily, the same may be recorded in the confidential reports and a copy thereof supplied to the affected officer so that he will have an opportunity to know the remarks made against him. If he feels aggrieved, that it will be open to him to have it corrected by appropriate representation and so on, so on. That is a settled law.
Yes.
Now, Lordship, the respondent number 2, who is the DGAR, while disposing my representation, did not consider all this aspect. Rather, endorsed the that is, Lordship, kindly come to the, we come to page 92, typed copy of the in speaking order.
Yes.
Lordship, when the respondent number 2 has disposed my representations, various several representations, while complying with the direction of the Honorable Court, has not given any reason why they have rejected my representations. Rather, they have endorsed only the findings of the reporting officer and the reviewing officers. They have only endorsed the findings, Lordship. The operative part is starts from page 93. Page 93, paragraph 5 of the speaking order. I may be allowed to read.
Yes.
Page 93 of the type copy, Lordship, page paragraph 5. And whereas in compliance with the judgment and order dated 5 December 2023, passed by the Honorable Gauhati High Court, Kohima bench, passed in resolution number so and so, the representation submitted by Subedar Rajkumar Sarkar have been considered by the competent authority keeping in view the following aspect. Benchmark for performance appraisal promotion and benefits under modified Azure progression scheme has been enhanced from good to very good. Government of India, Ministry of Personnel, and so and so, so and so. Accordingly, the EBIT policy has also been implemented in the Assam Rifles Act with effect from 1st January 2016 for grant of promotion and benefits of financial application under modified modified Azure career progression scheme. As per the EBIT policy, all employees are required to earn at least very good grading in all confidential posts from the year 2016 onwards. On perusal of the SAR for the assessment year 2019-2020 in respect of the JCO, it has been revealed that the JCO has been graded average 4 in the SCR to be his reporting officers and not recommended for further promotion based on his performance during the assessment year. The grading by the reporting officers has amply justified by the reporting officers in the pen pictures of the JCO endorsed by them. On detailed examination of SCR 2019-2020, it has been observed that the gradings awarded to the JCO by the IO and RO have been amply justified by the reporting officers in the pen picture that average JCO who need to improve upon his discipline, integrity, and professional conduct. Warning letter for the same was given to the JCO dated 8 June 2020, and reporting officer endorsed the JCO's pen picture as average JCO who does not respect and follow laid down rules and regulations of service and try and create unhealthy environment in the unit. It is evident from the pen picture endorsed by his reporting officer that the JCO's performance during the assessment year was poor and below the benchmark. Therefore, he has been rightly awarded the grading based on his performance. Moreover, during the assessment year 2019-2020, a warning letter was served to the JCO by his IO by 18 Assam fitness letter number so and so dated so and so for non-appearance for an inquiry initiated against him on the basis of the complaint filed by Captain Ankita Dhiman, RMO, for misbehaving and use of threatening language by the JCO, which also clearly indicate his lackadaisical attitude towards the discipline of the force. Here, Lordship, I'll just take a pause. In this event, what happened? Why I have not appeared? Because I was directed to appear in two places at the same time on the same date. Lordship, I'll just give explanation, Lordship, here. If kindly come to page 48. Page 48. Lordship, yes. Lordship, kindly come to page 47, annexure 8. So, Lordship, I'm just reading the operative part, that is paragraph 3. In view of the above, you are hereby ordered to report to the presiding officers at KLP Modi by 9 June 2020, failing which appropriate disciplinary action will be initiated against you as per Assam Rifle Act 4. So, Lordship, kindly come to annexure 1, annexure I, page 48. Next page. Here I've been, Lordship, I've been directed.
This is a movement order.
Yes, Lordship, on 9 June 2020. So, Lordship, how it is possible, Lordship? Two place, same date, same time. How I can comply, Lordship? And in my representation.
This page 48 is for what? Appearance for what?
Lordship, for treatment, Lordship, for movement order for treatment, Lordship. For treatment. For medical treatment, purpose for journey, for medical treatment. And page 47, they are saying that I have to appear before a court of appeal on 9 June 2020, and 9 June 2020, a movement order also issued. And this aspect I have taken in my representations before the respondent number 2. But the respondent number 2, while disposing my representation, did not consider this aspect also. And Lordship, both the letter was issued by the same person, the respondent number 6, Lordship. The respondent number 6. Both the letter was issued by the respondent number 6. Now, Lordship, can we come back to the input speaking order, page 93, paragraph E. On perusal of the APA for the assessment year 2020-21, 2020-22, the reporting officers have graded him 5 points and not recommended for further promotion based on his performance during the assessment year. The gradings awarded by the reporting officers have been amply justified by the reporting officers in the pen pictures of the JCO endorsed by them. The grading awarded by the reporting officers to the JCO has been aptly justified by the reporting officer on the pen picture endorsed in the APA, that the JCO is insufficient to carry out tasks assigned to him independently. The JCO needs remarkable improvement in his professional skill and attitude towards work. And reviewing officer assessed and endorsed the JCO's pen picture as JCO keeps his personal interest always above the organizational interest, a liability to the organization. This remark clearly indicates the poor performance of the JCO during that period. ACRs in respect of JCOs were regulated by the ROI 1997, and para 40 of the EB ROI provides weak point adverse remarks of reporting officer in the CR will be communicated to the JCO in writing. In this said case, the said provision has already been complied by communicating the extract adverse weak points to the JCO by 18 Assam Rifle by letter dated so and so. Lordship, in paragraph number 3, paragraph number 8, they have said that the extract of apple was also communicated to me. Now, Lordship, kindly come to paragraph number 7, which is the important one. Now, therefore, in light of the facts and circumstances enumerated in the preceding paragraphs, the competent authority, after detailed examination of the representations of the petitioner dated 6 so and so, is of the considered opinion that the request of the petitioner to upgrade his SCR awarded to him by his reporting officers purely on the basis of the performance during their respective assessment years lacks merit, therefore is hereby rejected. So, Lordship, when the respondent number 2 has passed this impulse speaking order, has not given any reason why they are rejecting my representations. Only they have endorsed the findings of the respondent number 5 and 6. Now, Lordship, in this regard, I rely on one decision of the Honorable Supreme Court. Lordship, kindly come to page 48. Page 48 of my compilation. Paragraph number 35. Yes. Page 48, paragraph number 35. Reasons when recorded by an administrative authority in an order passed by it while exercising quasi-judicial functions would no doubt facilitate the exercise of its jurisdiction by the appellate or supervisory authority, but the other constitutions referred to above, which have also weighed with this court in holding that an administrative authority must record reasons for its decision are of no less significance. These considerations show that recording of reasons by an administrative authority serves a salutary purpose, namely it excludes the chances of arbitrariness and ensures a degree of fairness in the process of decision making. The said purpose would apply equally to all decisions, and its application cannot be confined to decisions which are subject to appeal. Revision or judicial review, in our opinion, therefore, the requirement that reasons be recorded should govern the decision of an administrative authority exercising quasi-judicial functions, irrespective of the fact whether the decision is subject to appeal, revision, or judicial review. It may, however, be added that it is not required that reason should be as elaborate as in the decision of court of law. The extent and nature of the reason would depend on particular facts and circumstances. What is necessary is that the reasons are clearly and explicit so as to indicate that the authority has given due consideration to the points in controversy. The need for recording of reasons is greater in a case where the order is passed at the original stage. The appellant or revisional authority, if it affirms such order, need not give separate reasons if the appellate or revisional authority agrees with the reasons contained in the order under challenge. Lordship, kindly come to page 49, paragraph 39. For the reasons aforesaid, it must be concluded that except in case where the requirement has been dispensed with expressly or by necessary implication, an administrative authority accessing judicial or quasi-judicial function is required to record the reason for its decisions. Lordship, I also rely on this aspect. I also rely on one decision of the Allahabad High Court.
No, the appellate authority if it agrees with the original order, then it need not give reasons. Only if it disagrees, it has to give the reasons.
But Lordship, there is no order. The appellate authority here only supervising, disposing my representations. There is no order.
They have
There is
said
no
in
order.
the speaking order, they are saying that they have agreed with the gradings given by the reporting and review.
These are not the orders, Lordship. These are the gradings. This is not an order.
So
These
they are
are the-
agreeing with the gradings.
Lordship.
Then
I also rely on one issue regarding this decision. This reason should be given. One judgment of Allahabad High Court, Lordship, page 50. And the relevant part, because it's very lengthy, I'm just mentioning the paragraph that is paragraph 7, 8, and 9, Lordship. Page 52, paragraph 7, 8, and 9. It will end, Lordship, at page 60, from 52 to 60. Why reasons should be given?
Paragraph 7, 8,
and 9.
and 9. Okay.
Lordship, kindly come to my representation, Lordship. Which will highlight, Lordship, whatever the points I have taken, that was never adjudicated by the appellate authority, Lordship. Page 80, annexure N. Point number 2, Lordship, I'm reading. Point number 2. That, sir, IO Major Shubhadeep Paul, adjudicator, has written in para 17 of pen picture stating that the JCO is inefficient to carry out tasks assigned to him independently. The JCO needs remarkable improvement in his professional skills and attitude towards work. That, sir, it is brought to your notice that I did not perform any official duty under IO Major Initiating Officer Major Shubhadeep Paul for the period of report. As per policy, I should have observed the duty, responsibility, and tasks assigned to his subordinates at least continuously for a period of three months during the period of report. But he did not assign any task, responsibility to me as per my charter of duty. Therefore, his remarks in pen picture is highly objectionable and needs to be reviewed. Worship, now kindly come.
Then 3.
Point number 3. Yes, sir. Reviewing officer Colonel Adit Khetri, Commandant, has written in para 20 of pen picture stating that the JCO keeps his personal interest always above organizational interest and liability on the organization. The above mentioned remarks was written without any substance, and to the contrary, I have sacrificed all my personal interests in discharging my duties to the entire satisfaction of my superiors from the date of my appointment since joining in Assam Rifles on 12/5/1989, and has been continuously serving in field areas of Assam Rifles battalions and sector headquarters, leaving behind all personal comforts and education and welfare of my children, and has been sacrificing the well-being of my old aged and ill parents only for the organization's interest. I have been promoted from rifleman ORL to Subedar Saipal during the period due to unblemished and outstanding service in Assam Rifles. Therefore, comments given by RO appears to be motivated and mollified and has given intention to spoil my future career of service. Moreover, RO is only empowered to comment in respect of my performance in assigned government duty as per rule prescribed by the central government for writing apart. RO cannot interfere in my personal matter, making such recordable remarks in apart against a government servant who has rendered 33 years and 8 months of unblemished service in force. Thus, it is also submitted that during my service career prior to the filing of the requisition number so and so, before the Honorable High Court of Manipur, I have not given any adverse remarks in my part, and as such, the present adverse remarks which were awarded by the authorities needs to be urgently attended and reviewed. More particularly, I have not been served with any show cause notice for reprimand or recordable censure was awarded to support the adverse remarks given in present apart. That's Commandant 21, Sector Assam Rifles, being conformative authority, has not also verified reasons for adverse remark recorded in my apart and simply agreed with the contention taken by the IO and the R. So, Lordship, whatever the contention I have taken in my representation, that was never addressed. That was never addressed by the respondent number 2 while passing the impute speaking order. And interestingly, Lordship, in my SCR or FR, I have received those adverse entries only when the respondent number 5 and respondent number 6 were the initiating officer and reviewing authority. Besides, Lordship, in the year 2020 to 2020, yes, 2020 to 21, I received very good rating. Then, Lordship, after 2023 to 24, I have received good, very good, all the time. It is only when the reporting officer and the reviewing officer are the respondent numbers 5 and 7, my entries were bad.
After 2020,
Lordship.
after 2022.
Lordship, accounting from 2019 to 2024, 5 years, which is considered for promotion. So, Lordship, in 2019, I have received bad, and then 2020, I received good. Then, Lordship, on 2021, also good. Then 2022, bad. Then 2023, like this, Lordship. Only 3 years I have received good, and 2 years I received average. That is bad. Bad at percentage, and that is only when I was serving. When the IO and the reporting officer was respondent number 5 and respondent number 6. And the same appointment, and the same as I have made appointment, Lordship, in my repetition also. Page number 26. Para number 26, page number 24, Lordship. I have made an appointment regarding this. Para 26, page number 24.
Okay. Okay, you wind up now.
Yes, Lordship.
Respondent 5 and 6. Yes. Respondent 5 and 6, isn't it? The initiating officer and reviewing. Okay. Should we continue at 1? I mean 2. How long will it take?
I'll take on short time.
Short time.
Yes.
Okay. Yes.
Yeah, listen. My lord, the present application is rest of the guy. My lord, initially they tried to do
1 minute, 1 minute.
there's another second under there. This price will be upgraded. And no other than the minutes of the forward to there.
What happened? You said res judicata.
Petition number 294 of 2023.
294.
Yes.
Oh.
Petition number of 2023. The petitioner has filed petitions. Second in the
That earlier petition?
yes, yes. So that according to this one court is disposed of the rectification. I think the respondent consider the recommendations of the petitioner.
No, his representation was not disposed of.
No, as per the directions of this one.
That's why.
Yes,
That's why a direction was given to dispose of the representation.
Yes.
So this is a different thing. And now this time in this petition, he is challenging that disposal order as well as the ACR gradings.
The one of the similar opinion, similar situated things so that it is also
No, in the first petition also this same prayer was there.
yes, so that paragraph 4 of my academic provisions. Yeah, my lord.
Yes, yes.
The petitioner filed a petition, PPC number 294 of 2020, honorable for qualified for praying and the lab director Assembly authority will dispose of the representation dated 6/9/2021, 19/12/2022, 6/1/2023, and 27/10/2023. And to upgrade the tracking of the ACR operate a part of the petitioner for the period of 2019 to 2020 and 2021 to 2022. And further direct not to remove any junior officer prior to the disposal of the representation. So the same ground, the same party matter, the petitioner is raising the same issue.
No. In WP 294, the prayer was to direct the authorities to dispose of his representations. And in the present one, he is challenging the disposal order. Because the court directed that the representation should be disposed of. And that was accordingly disposed of.
Yes.
So now he's challenging that disposal order. So these are different things, not the same issue.
So the message of that rural court order, the respondent has considered examining the representation of the rectification. And now, as per the accordingly, the honorable court transmitted order dated 5 December 2023, direction that the respondent number 2, respondent number 3, and respondent number 4 shall have to consider trying to take the decision as to which authority higher can take authority who gave the grading and the ACR apart from year 2019 to 2020 and for the year 2021 to 2022. These to examine and take decision on the petition represented 6/9 as I mentioned earlier, the 4 representation. Therefore, the children authorities should not. Thereafter, the children authorities should decide the petition representation. The entire exercise should be concluded within a period of 3 weeks from the date of the receipt of the subject copy of this order. The decision taken by authorities should be recommended to the citizen. Yeah. Then thereafter, after considering that by petitioner representations, the authority concerned, I attend the authority holds in the matter. So that after examining all these representations, was recognized. I know my learned friend has mentioned everything, so that he's saying that everything is examining all of the documents. Now, regarding that petition number 27 of 2020, which one is filed in the High Court of Manipur in Parliament? There, that one is as per my paragraph 16 of my statement of position.
The charge sheet, he has
Yes,
challenged the charge sheet.
Yes. That with regard to paragraph 1, the conditions of the petitioner is not agreed to. Then the charge sheet served to the petitioner where in respect of act committed by the petitioner. Petitioner served to the court order and discipline. And the petitioner approached the Honorable High Court that empowered the state the disciplinary proceeding pending against him. The same was suspended by Honorable Court of Empowered Order dated 28 January 2020. So that the matter is still and still in the High Court of Manipur. Of
That
course,
is again a different issue.
Yes.
That is challenging he has challenged the charge sheet.
She is mentioning everything, allegation against the Congress matter. So that the paragraph wise, I'm responding to the allegation part.
Okay.
And also certain by the case of not court. So he is coming here and there. So that basing on that, my lord, he is planning for this apprehensions of his creating. So I just have to reply to all the paragraphs, which my lord that we submitted my. So now paragraph 17. That with regard to paragraph 7, it is submitted that amendment of the petitioner has been modified. And the petitioner was not released from 18 Assemblado to 21 Assemblado. His notice was issued to the petitioner informing him of the court of inquiry being condemned to investigate the circumstances under which the petitioner misbehaved and abused petting language with the unit petting medical officer, Captain Ankita Tamin. The petitioner failed to report to the petitioner presiding officer of the court of inquiry and was therein one that on failure of the reporting appropriate petitioner action will be taken against the petitioner. Being agreed by this court of inquiry, against him, his wife filed a petition on behalf of her husband. The one is in the court of High Court of Manipur, bearing the group PC number 494 of 2020. But he is saying that he is transferred out to the Akatala 21st Assembly Court. But this very repetition is exposed on then 2020. And now he is saying that so many allegations against the respondent Malcolm. So now I have here clearly mentioned that. However, the court by judgment and order dated 10 September 2020 directed that the instant petitions stand accordingly disposed of with the directions that the petitioner husband may submit legal representation to the Director General of Assam. So that what I'm saying is that the petitioner husband wife has filed red petitions, not by the petitioner, on behalf of the present petitioner. submit detailed representations to Director General of Assam Rifle, General. The respondent number 2 here within a period of 2 weeks from today, either through email, WhatsApp, or by hand or by paper, and the evidence of such representative being submitted by the petitioner husband. The Director General of Assam Rifle.
This is in respect of the transfer. This
Yes, yes.
WP 494.
Yes.
The first one, the first
one
WP is regarding the court of inquiry, tentative charge sheet. Then this 494 is against that transfer.
Yes.
So it was disposed of with the directive to dispose of the representation.
Yes. After submitting the representation to dispose of the representation memo. So that here,
Okay.
according to this judgment, this order, the petitioner should be transferred to the court there and after that. The honorable court has not said anything, mentioned anything. So may conduct by that way.
Yes, then.
So that shall consider it and dispose of within a month from the date of receipt of the representation by issuing a reason and speaking order. It is made clear that this order shall not preclude the respondent and the particular respondent number 3 from releasing the petition husband to the during his proceedings at a new place of posting at Akatara in terms of transfer order. The judgment of order is annexure 1.
Okay.
Annexure 1, page, I'm going with the paragraph. Page 20, paragraph 5. This is the order. This is the order. Well. We are written.
Yes.
The instant petition stands accordingly disposed of with the directions that the petitioner has been made submit detailed representations to the Director General of Assam Rifle, Shillong, the respondent number 2, herein within a period of 2 weeks from today, either through email, WhatsApp, or by hand or by spread post, and in the event of such representative being submitted by the petitioner husband. The Director General of Assam Rifle, Shillong, shall consider it and dispose of within a month from the date of receipt of the representation by issuing a reason and speaking order. As the petitioner's husband is not permitted to move out of the game as alleged in the petition, he shall be granted permission to by the respondent number 3 to meet his advocate or his advocate may be permitted to meet him in the game so that the petitioner husband may be able to submit his representations. If so advised, and then if the petitioner husband is agreed by such an order to be issued by the respondent number 2 as regard the representation, it is open to him to approach any appropriate forum for procedural of these clearances. Any penal or coercive action if not already taken shall not be taken against the petitioner husband till the disposal of his representation. It is made clear that the order shall not preclude the respondent and in particular the respondent number 3 from releasing the petitioner husband to join the duties at the new place of posting. At Agartala in terms of the transfer order dated 27/11/2019. That is the order not moved out. So that
No, but what has this got to do with the ACR remarks?
there's nothing to do.
Nothing to do.
I don't finish allegation all those things, the respondents.
No, those we will not look into it. We will only consider extraneous, whether there is any extraneous consideration for making those remarks. That's all.
Yes, so, my one friend is allegation of all the
Allegations, there are many allegations.
respondent now. So I'm
Okay.
submitting all those allegations and replying to this allegation. Now, my second allegation, my learned friend has said, second allegation is that with regard to the paragraph 8, the available petitioner is fabricated. Paragraph page 9, paragraph
18.
18 is. Yes, the petitioner went to Assam Rifle Hospital on 27/4/2020. As I stated, my lord, the petitioner has filed the petitions of the Manipur Empower, High Court Manipur Empower. That very order is passed on then September 2020. And now he is saying that such false allegations is making against the respondent. As been went to Assam Rifle Junior Hospital on 27/4/2020. That is before the order of the Honorable of Manipur High Court passed on 10/9/2020. However, the petitioner has conveniently stated and coordinated to search his case by averting that he went to form annual medical examination after the issuance of the transfer order. So, we'll come to the point by law. So now his medical examination she's saying all these things, but we'll come to the conclusion that he is just fabricated all these things. So and now he is making allegations that what to say, those things are not those pathologists and microbiologists were not qualified. That's what he is an allegation against the respondents. So now the initial 2. That one is the certified issue by the competent authority. That one is.
You're trying to say that the
Yes,
laboratory assistants in the lab, they are qualified.
Yes, they are qualified. And now my previous allegation is that they are not qualified. So in order to wash his hand, he is taking allegation against the respondent. So the page 22, annexure 2 is there. Qualified person, which certificate is issued by the armed forces medical service. That one is the certificate issued by the competent authority.
Okay.
And now paragraph 19 level. That with regard to paragraph 9 and 12, the appointment of the petitioner are not agreed with the regional medical officer, Captain Ankita Chairman, submitted a written complaint against the petitioner where she stated that the petitioner treated and misbehaved with the medical officer on then May 2020. That one is initial 3 by law. This is complaint letter submitted by the medical officer and it and nearly allowed to the initial 3 to based in 3. It is intimate that non-participating subsidiary cyber or this unit who has been admitted in unit hospital with effect from 10 May 2020 for his 6-hourly PT monitoring as advised by the medical specialist IGR South ARMS has taken and misbehaved with undersigned at around 12:20 hours today. The matter has been informed telephonically to the student at around 12:35 hours today. While taking what around the undersigned has asked the above mentioned GCO about his well-being. Then he started accusing that he has been intentionally admitted in the unit hospital by the undersigned. He also mentioned that the he also mentioned that the detail endorsed in this case sheet are wrong. These reports are normal and that it does not need any kind of monitoring. During the conversation, he also commented, "Madam, I'm not born after eating amul like you. I have starved in high altitude area and I'm not weak." Thereafter, the undersigned had advised him to give and writing about all his complaints rather than unnecessary agree. Then he started threatening the undersigned by saying, "Madam, I will see you later and give and writing to whosoever I want. To. Moreover, sometimes put pressure on paramedical staff to check his BP repeatedly and order him to endorse letter and pass rating of BP and his case sheet. That was signed by complainant Nikita Yemen. Hello? Paragraph 20, page 9. That with regard to paragraph 10, it is submitted that the issue post notice was issued to petitioner on 28 April 2022. Petitioner, as he refused to be admitted in the hospital when advised to do so. After monitoring of this plot report and ECG, copy of plot report and ECG attached report. That one is line prayer also mentioned. So the annexed report is copy of plot report and ECG attached. That one is on page 24. The petition that the Assembly Hospital again the advice of the medical officer after signing the written statement for if the statement is attached as an issue 5. So the one is the issue 5 is question 6 is duty and duty, so that the translate for B is page 3 is the issue 5. BRA. ITC treat numbers such as that of September Cyber Rajit Kumar, Sarkar is 52 years, having completed 32 years, visited medical inspection MI home for annual medical examination AMI on 27 April 2020. During medical inspection, it was found that my blood pressure was high in some anomaly observed, and the ECG also. Doctor residing in my unit consulted with medical specialists of IGR South, ARMS, and on medical specialist advice, Dr. told me, get admitted in the hospital for better monitoring. I didn't listen to the doctor's advice and not willing to get admitted to hospital. Commandant Sir also advised me to get admitted in the hospital, but I don't listen to him also. In future, due to my illness, if I face any problem or anything bad happen to me, I will be so responsible for that. Battalion, doctor, medical staff, or anyone else will not be responsible for that. So the one is he is trying to admit this to so that he is signing these things and he is staying very quickly. And now by paragraph 21. That with regard to paragraph 11 and 12 are 13, the appointment of petitioner is not with the medical specialist. I said, so by case sheet number doesn't prove. Also, that the petitioner is fit to travel by route with one state attendant. However, the domestic text, the petitioner was the petitioner has averred that he was directed to move along the path. Further, due to non-cooperations of the petitioner for pregnant attend as rifle and considering his abnormal this reference, the petitioner was referred to as rifle notice specialty hospital IGI. So the annexure 6. Annexure 6 is yes here. Which page 28. Annexure 6. This is with regard to the patients. Right.
Page 28.
Yes, well.
Is fit to
Advice refer to IGI of as for further evaluation and management by me specialist. GCU is fit to travel by route that is with 1618. But now he is saying that card with a card. So this one is with 1618. Now Madam is saying that with card, security card, something like that. All the investigation gets sheet and your sheet card and handed over to the safe attendant. So paragraph, I'm going to read my current application. And now, paragraph 22. That wherever appointment made by the petitioner and paragraph 14 and 13, it is submitted that ACR respect of petitioner were regulated by their report for his instruction ROI 4/1997, paragraph 40 of the EPIC ROI provides. Waypoint average remark of reporting officer to be communicated to the affected individual. On the third examination, whereas ACR 2019 to 2020, it has been observed that the granting award to the petitioner by initiating officer and reviewing officer have been implied justified by the reporting officer in the pen picture that an average GCU who need to improve upon his discipline, integrity, professional conduct. Warning letter for the same was given to the GCU that June 2020, and the reporting officer endorsed the petitioner pen picture as an average GCU who doesn't respect and follow lay down rules and regulation of service and thrive in great unhealthy environment to the unit. That was annexure 7. That pen picture is annexure 7.
Page 29.
29. 30. 29, yes. 29 to 30. May I read all these things for you? I think if the congregation will get this validating. So that
Yes, we have already seen.
maybe it's all right. But page 29. And competition qualification. This is the regard of the definition of qualification. Here is under the degree officer. That one is.
No, but why you have not furnished all this to the petitioner?
My lord,
You have only furnished that point, number 4, that you have given him grade 4 grading. But all this remarks you have not furnished. This
I have an extract of that one is my.
average JCO who needs to improve, then average JCO who does not respect and follow laid down rules. All this was not provided to him.
This is provided to him, my lord.
No, in the petition, the document which was provided to him, that doesn't have any of this. It just has that grading number, grading of 4. Where is that? Your petition page?
Well, they have annexed with their worship and come to page.
Page 34 of my lord.
Page 35, where they have only communicated the.
This 34, 35, page 35 only you have communicated. See?
Page
30, your page 35. Here you have stated extract of adverse / weak points in the pen picture, right, such and such. But there you have not put any of the pen points, pen picture or any of the adverse remarks. You have only given this 4, see, 92 by 4, 93 by 4, only that much.
my lord, that competition report page 34. I have mentioned the extract of adverse weak point and the pen picture by para 15 to 16 of page number 4 of ECR for the period from 1st September 2019 to 31st August 2020 is forwarded here with in duplicate for you information and signature thereof. Page 34.
Yes.
Yes, I have.
In your covering letter, yes, you have stated.
This one I have issued to the petition, ma'am.
True. In your covering letter, you have said extract of adverse weak points in the pen picture, but actually, in reality, you have not given. You have given only this one page. See, this page 35 only. Whereas in your ACR, in the ACR, so many things are written there, but nothing has been said, nothing has been provided to the petitioner.
My lord, as per this confidential report, that was annexed at A. The respondent has issued that this annual confidential report.
No, how do you show that you have served? Even in your reply itself, you have only given one page. And your affidavit in opposition is all just denying the allegations only.
Yes.
Nothing is said about the entry in the
Now, as per
SPR
the report,
and how the authorities came to the conclusion that he deserves average or below average. Nothing is there. And then the speaking order also, no reasoning. The disposal order also, there's no reasoning. The petitioner has specifically made certain points in his representation, saying that he had not even worked with one of the reporting officers, one Major Shivati Paul, that he had not even worked with him, and he had not carried out any task under this Mr. Shivati Paul. So how that person has written his ACR? So many things are there which you have not replied at all in your reply, in your counter affidavit. Anyway, yes, what else?
it is written that on conditions of that my paragraph number 22, my lord. And it should 7 is completed and now annexure 7, 8. It is evident from the pen picture endorsed by the reporting officer of the petitioners that the performance of the petitioner during the assessment year was poor and below the benchmark. Therefore, he has been rightly awarded a granting based on his performance. The above mentioned first point for communicated the petitioner in writing. Yes, that's what I'm saying, my lord. Copy at this section 8. This one is my initial, which I have stated. This communication is communicated to the petitioner. And now, paragraph 23, my lord. That with regard to paragraph 16, 17, it is submitted that both introductions of APA, that one is with regard to which one I have submitted this with regard to Asia before the introductions of APA. That with regard to paragraph 16, 17, it is submitted that both introductions of APA for assessment of personnel, the same was governed by Record of Place Instruction 1/2021, para 37 of which provides that the interest endorsed by the reporting officer will be communicated directly. But also apart for the assessment year 2021 to 2022, the reporting officer has graded him 5 points and not recommended further promotion based on his performance during the assessment year. The grading awarded by the reporting officer had been implied justice by the reporting officer. Officer, the pen picture of the petitioner endorsed by the team that JCO is inefficient to carry out tasks assigned to him. Independently, the petitioner needs remarkable improvement and his professional skill and attitude towards work. And the reviewing officer assists and endorses the petitioner's pen picture as the JCO keeps his personal interest always above the original interest, liability to the organization. The above remark clearly indicates that both performance of the petitioner. So that annexure 9 is that apart communicated to the petitioner because he is getting below the benchmark color. That one is annexure 9. So that in this, he is getting 5, 5, 5, 6, 5, 5. His performance. So this one is also communicated to the petitioner by type copy of annexure 10, page 42. That extra copy is also communicated to the petitioner by letter dated 28 December 2022. And which one? First is here. That one is communicated to the petitioner on 9 June 2021.
And this one is December?
That one is communicated to
28 December.
28 December, yes.
This one you have received 28 December 22.
Received and I have enclosed with my reputation.
But the earlier one you have not received.
No.
That one is also communicated to
19 to 20.
as per the permission received from here. Extract of the address. That one is 9 June 2021. That one is also communicated to the petition, my lord. Page 34 of my affidavit of petition.
Then,
Paragraph 22, that with regard to paragraph 22, it is submitted that the assessment of Assam Rifle is not restricted to a specific duty, but the overall assessment of the RIP. It is pertinent to mention that RIP are assessed on both output, personal attributes, and functional competency. Therefore, conditions of petition does not agree to copy of the sample apart with the teach as annexure 11 for reference. That one is plain for the reference of the Sonoma report, page 51, the annexure 12. Given in view of all these things, my lord, this recognition be if it gets to dismiss on the ground of the statistics, that much more.
Very short report.
yes.
Firstly, Lordship, they have raised some issues in their counter affidavit at paragraph number 18. They are saying that as per the petitioner, went to 18 Assam Rifle Unit on 27/4/2020. That is before the order of the Honorable of the Manipur High Court passed on Sanso. However, the petitioner has conveniently stated the facts incorrectly to serve his case by averring that he went annual medical examination after the issuance of the aforesaid transfer order. Lordship, to this I replied in my rejoinder at paragraph number 19. Sorry, Lordship, paragraph number 9, page 4, in my rejoinder. Page 4, paragraph 9. That while denying the correctness of the statement made in paragraph 18 of the F15 opposition, the answering deponent petitioner begs to submit that the respondent has misread the averments of the deponent petitioner made in paragraph 8 of the petition, as the deponent petitioner has categorically stated that after the issuance of the aforesaid transfer order, that is transfer order dated so and so, the deponent petitioner had went for annual medical examination, that is before passing of the judgment and order dated 10/9/2020, with the Honorable High Court. Further, it is also submitted that by the F15 opposition, the respondents has tried to impose upon this Honorable Court that the nursing assistant who has conducted tests upon the petition is a qualified nursing assistant. In other words, the respondents has tried to justify that said nursing assistant is equally qualified with that of a pathologist, microbiologist, etc. And therefore, there is no need for a pathologist or microbiologist, and the report prepared by the said nursing assistant was absolutely accurate. However, it is respectfully submitted that a pathologist, microbiologists are medical doctors, scientists, having specialized knowledge and skills in diagnosing and studying disease, while a nursing assistant provide direct patient care under supervision of a registered doctor, physician, and therefore tests conducted by the said nursing assistant is not tenable and acceptable. Now, Lordship, 18. Now, Lordship, the learned CCC has also relied on that the Honorable Manipur High Court has directed me to file a representation, which I have earlier also submitted. But they have failed to make any clarification that whether my representation was considered or not. And if not considered, why? Till date, it has not been considered. So they have not disclosed these facts. Secondly, Lordship, now
That representation not disposed
not
of.
yet disposed of. Whereas the Honorable High Court, Manipur has said that the said representation has to be dismissed
Within 2 months.
2 months, Lordship.
That representation not disposed of,
No,
Mr.
no,
Nguli.
Lordship. Excuse me.
Mr. Nguli, that representation not disposed of.
No, I got my instructions.
Not it.
Not properly instructed without regard, my lord.
That means you have not disposed, because
Hmm.
if it was disposed, you would have enclosed
Yes.
in your reply.
Then Worship, here the entire counter affidavit is supporting the nullified the acts of the respondent numbers 5, 6, and 7, where the respondent number 2 was not there also. It was there present. Worship. When they have passed the speaking order also, they have just relied on the findings of the respondent numbers 5 and 6. They have not made any inquiry while passing the speaking order. Now, Worship, particularly the paragraph number 22 of my writ petition, where I have categorically stated that except these two adverse entries, I have not got any adverse entries. And I have got those adverse entries only when the respondent number 5 and 6 was my initiating and reviewing officer. However, Lordship, in their counter affidavit, the respondent did not make any averment regarding this. No direct averment is come. Now, Lordship, kindly come to page 6 of my rejoinder affidavit.
Page 6.
Page 6 of my rejoinder affidavit, paragraph 11, that it regard to the statements made in paragraph 20 of the affidavit opposition, it is respectfully submitted that an ECG should be done by an ECG technician. However, in the case of the petitioner, the same was not done by an ECG technician, and therefore, sensing some foul play, the deponent petitioner had only requested the Captain Ankita demand that he may be allowed to go to any other hospital to get tested for more accuracy and to clear his doubt. And to this, the respondent number 7 got offended, and therefore the respondent number 7 has directed the deponent petitioner to append his signature in a written statement drafted by the respondent number 7. Further, it is submitted that the deponent petitioner has not received any show cause notice dated 28/2020. However, Lordship, in their counter affidavit at paragraph number 20, they have stated that they have served me a show cause dated 28/2020. I have not received any show cause notice 28/2/2020. However, Lordship, the respondent was issuing the show cause notice dated 28/4/2020 and 29/4/2020 that the deponent petitioner was not afford a reasonable time for reply, and to cover up this lacuna, the respondent is endorsing the arbitrary act of the respondent number Commandant 18 Assembly. Now, Lordship, my argument is that paragraph number 12, that with regard to the statements made in paragraph 21 of the affidavit in opposition, it is respectively submitted that the respondent is deliberately ignoring the fact that when the health condition of the deponent was reviewed by the specialist of the Assam Rifles Multi-Speciality Hospital, Manchipuri, it is certified that the deponent petition does not have any health issues, thereby proving that the medical report prepared on 23/4/2020 by the 18 Assam Rifle Unit was not correct, and also the allegation of the respondent number 7 is baseless and conflicted. And my last submission with regard to the principle of res judicata, Lordship, here Lordship, an earlier petition, this honorable court was directed only to
disposed representation.
Yes. Other matter was not adjudicated. And the principle of res judicata applies only when the matter has already been adjudicated. Besides, Lordship, a fresh course of action is also there. That's all.
My pleasure, Chief. My lord has recorded Annex 7. of page 29.
Mhm.
Whether the petitioner has received that ASAR report or not. That one is that the petitioner has received, as I stated, that.
No, he is admitting that he has received.
No, madam, that am I received by
For
below those things, confidential report, my lord. Received by Sepidar, he signed over there, my lord.
where is that page?
Page 29. Page 29, annexure 7. Right side, received by GC, such and such Sapita, Cyber, Rajiv Kumar Sarkar, headquarter, company, 18 Assam Ratau. That one is signed by the petitioner. And now you comment saying that he is not received those things. And here, page 30 also, he signed over that. And page 31 also, she received it and signed it by my lord. So that there is no dispute. He is already received it. But to clarify this on our court map.
Lordship, I may be allowed to clarify this signature.
Yes.
Lordship, this signature is that when the extract copy was given to me, I was told to sign, and I have signed. Whereas there is no evidence, there is no document showing that the copy was given. Only that extract copy was given. Even if I signed also, how it is proof that I have received the entire copy? I was told to sign when they have given me the extract copy. That's why I have signed. That is purely misleading, Lordship.
No, your signature is there.
Yes, Lordship.
On
Yes,
the other page.
admittedly, because
Inside
when
also.
they have given me the copy, that is, Lordship, kindly come to page.
See their
Yes, Lordship,
affidavit
page
in
34
opposition.
of the counter affidavit, page 34. When they have given me this forwarding letter, they have asked me to put my signature there. Then I have signed it, but the copy was not given. Mere giving signature does not imply that I have received the copy.
No. See at page 31.
Yes, Lordship.
Page 31 at the bottom. There also your signature
Yes,
is there.
that's
Then,
true, admittedly.
then
Admittedly.
page
Page 29 and 30. Page 29,
29,
30,
31.
Yes, admittedly, Lordship. I was told to sign. I have signed. When they have forwarded me this letter, forwarding letter, along with this extract copy of adverse here, they have told me to sign. I have signed. But there's nothing on record. They have given me this copy of the ACMs. Just mere having my signature does not imply that I have received a copy of the FIR.
Okay. That's all.
Item number 2 is connected with
What is this review?
review is, Lordship. During the pendency of this writ petition, I filed one IA with a prayer to direct the respondent number 2 to refrain them from holding upcoming DPC. But during the pendency of this IA, the respondent has misled this honorable court by submitting that DPC was already done. So this IA has become infructuous. Whereas my prayer in the IA was very much clear that DPC for the upcoming year, that is 2020-25, And they have placed on record before this honorable court the DPC of 2020-24. By misleading this honorable court, they have gotten favorable order in favor of them. However, during the pendency of this review application, they again conducted the DPC, and they have not selected me in the DPC also. That is, they have filed their counter affidavit also. Yes, Lordship. And they have enclosed one DPC, that is annexure page 5. There is no annexure. Page 5. Yes. Yeah. That is in page number 5. They are stating that my name was not selected during the pendency of this review petition also. Now they are coming with a plea that my review petition has become infructuous. And whereas, Lordship, my name appears number 1, Lordship, page 6, Lordship. Kindly come to page 6 of the counter affidavit. I was not selected only because of my adverse SES. Page number 6, in serial number 1, my name is appearing. Lordship, in the recommendation, that is the last column, not recommended due to lacking of SCR.
In the counter affidavit.
Lordship, counter affidavit in review petition. That is page number 6.
Page 6. Page 6.
Not repeat. That is last. My name is appearing in serial number 1.
This is the petition. Affidavit.
Page number 6.
Yes,
My name is
yes.
appearing as serial number 1. And in the recommendation column, that's the last column,
Not
they
recommended.
have made a remark not recommended due to lacking of SCS
Yes, for the year 2020.
for the year 2020 and 2022. So, Lordship, all these acts, it is showing that they do not want. They have made their mind that they will not promote me, that they will not select me. During the pendency of the review petition, they know that they are doing illegal things.
No, but that was way back in 2024. No, 2025.
2025.
Yes, by that time they had already held the DPC,
Yes,
isn't it? Yes.
I have filed my review petition in the year 2020-25. I have filed my IA also in the year 2020-25. Before they hold any DPC, I have filed one IA with a prayer to refrain them to hold any DPC for the year 2020-25. I have categorically mentioned in my IA, Lordship. But they have misled this court, and they have stated that the DPC for the 2020-25 is already done. And accordingly, my
No, but at this stage, we cannot review it. We cannot review it.
But Lordship, yes.
Because already,
this too,
yes,
Lordship,
it's already
but
held.
all these acts of the respondents clearly shows their malified intention, Lordship. Clearly shows their malified intention.
No, if the petition is allowed, everything will be rectified. And what is this? You have given one judgment, Jagdish Prasad. What is this for? Jagdish Prasad versus Chief Secretary, 2023 SEC.
Lordship, that is for that this honorable court can interfere with the adverse speciality.
Ah,
Actually, Lordship, this honorable court by order dated by order dated 21/11/2025 was pleased to hold that it is settled law that court cannot substitute its views. So for clarification, I have placed all citations.
Third counsel for the petitioner, Mr. Your name, such and such. Also heard Mr. Leonard Moody, learner CGC. Order reserved.
For admission, item number 4.
May I please, Your Lordship?
Yes.
Lordship, here, my senior, in the behalf of Indim Song, we have sent for the wedding. So kindly let this matter come up after 2 weeks.
Learned Government Advocate, Mr. Achungli Sangton, submitting on behalf of Mr. Im Song, the additional AG, prays that the matter may be listed after
2 weeks,
after
Lordship.
2 weeks, as the learned additional AG has some difficulties today. Yes, list of details.
For admission, item number 5.
Yes, yes.
My lady, I'm challenging the decisions taken by the village council. 2 decisions. Kindly come to page 99. 99.
Oh.
The first decision. This was taken, this is a so-called resolution purportedly passed on 29 January 2024 by the village, Sevenue Village Council. My lady, this village is in Sevenue district, in the district of Sevenue, and it's a remote village. Let's just read this. Joint village consultation meeting minutes between Sevenue Village Council and Okotso Village Council. Okotso village is in Wokha district. A joint village consultation meeting between Sevenue Village Council and Okotso Village Council was held on 29 January 2024, 10 a.m. at Sevenue Village Council Hall. The meeting held a detailed and threadbare deliberation pertaining to the matter of Mrs. Lucy Ma. My lady, Lucy is me, but I have never used the title Ma. I've always been using T. Lucy Muli. Wife of late Katie Thomas Mark. Katie Thomas, my late husband, belonged to this village, Sevenue Village, Sevenue Village. And resulted conscientiously with the following resolution in the interest of concerned family members, in particular, and both the villages in general. Resolution that Mrs. Lucy Mark will henceforth maintain amicable and better relationship with the family members of late Thomas Mark and adhere to the norms of the family. That as long as Mrs. Lucy Mark advised to be part and parcel of the family members of late Thomas Mark, she will enjoy all the privileges of befitting a full wife, be it pension benefits, occupying household or residence, etc. Presumed to be a dignified wife, she will automatically be deemed fit to forfeit all the claims and advantages of being the wife of late Katie Thomas Mark. 3. That Mrs. Lucy Mark cannot, under any circumstances, sell the immovable properties, namely lands and buildings, without consulting the family members of late Katie Thomas. 4. Rema Naga customary laws and traditional practices will be instantly imposed upon Mrs. Lucy Mark by the family members of late Kate Thomas without fear of failure in the event of infringing the resolutions of the Supreme Village Council in Latin Spain, signed by the chairman of the village council and the HGB of the village, Malay. Now, Malay, this is one. Then the next one, page 115.
114.
115. Now, lady, this is dated 21st January 2025. Meeting minutes, summon case against Mrs. T. Lucy Moon. Here, my name is Red King, wife of late British Council. The Penny Village Council had a summon case meeting and the complaint letter received from John Mark and Savio Mark on 3rd January 2025, along with the councillors and not family members of late Thomas Mark. Dated time of the resolution. On time of court. Whereas Mrs. T. Lucy Moon, wife of late Katie Thomas Mark, publication of the notice in the Nagaland Post dated 28 October 2024, applying for land papa at Springville, District Chumukima, under the title of Moody, instead of Mark, is a direct contravention of and contempt of court with special reference to the joint resolution between Seven Village Council and Okoso Village Council dated 29 January 2024, and at Seven Village Council Court. Further, the failure to appear for summon meeting on 21st January 2025 is an utter disrespect of the Seven Village Council. 2. Termination of privileges. In accordance with the Tasmanian landmark customary laws and practices, Mrs. T. Lucy Mooley has ceased to be a member of the Mark family. As a consequence, she is not entitled to pay monthly pension benefits, salary of late Katie Thomas. B. All immovable properties, including land and buildings. C. Mark family will not be responsible for any loan or mortgage against properties undertaken by Mrs. T. Lucy Mooley. D. T. Lucy Mooley should vacate the households or residence and lands within 30 days with effect on 31st January 2025. 3. Termination of citizenship. The Seven Village Council will not be responsible for any matter relating to Mrs. T. Lucy Mooley, as she is no longer a citizen of Pennsylvania Village Council, with effect from 21st January 2025, again signed by the chairman and the head chief. Now, my lady, the facts leading to passing of this such an orders by the village council. My lady, first of all, the petitioner is a Lata. She was born and brought up in Dimapur. Her parents belong to Okotso village, Wokha district. The property that they are talking about is situated at Sitovi village, Chumukidima district. She resides in her residence is in Purna Bajar. Nothing to do with this village in Seminyu district. Now, what happens? She was married to late Katie Thomas in 2011. She was a businesswoman, entrepreneur. Even prior to her marriage, she had her own income. From 2012 to 2016, 7 lands were purchased by 3 jointly by the husband and the wife, means joint income, 4 separately by her own income. These plots were all situated in Sitovi village and the adjoining villages. She bought one, then after that against her. Because she, in fact, my lord, she is one of the first persons to cultivate this dragon fruits. So she was doing that business. And in this farm, she has cultivated that, and she has also got everything is here, 1,71 lakhs from the NEC money for expansion in her name. Financial help from the NEC. Now, so she has developed this. The residence, she's residing in Pune Bazaar. The residence, this plot was purchased by the husband before they got married. But during his lifetime, in 2015, he gifted it to her. Pata is in her name. Husband died, exact date, 27, right? 27 January 2017, the husband died after a brief illness.
27 January?
Yes, 2017.
2017.
After the demise of her husband, she has constructed the residence. The residential building also was constructed after the demise. She's receiving the pension. Her late husband was a director in the tourism department. So she's receiving the pension. Now, after the demise, my lady, the relatives started eyeing the property because they don't have a son, no children. So started
No children.
My lady,
They don't have any children.
she has recently adopted one,
Okay.
but they don't have any children. So one girl she has adopted recently, but they don't have children. So they started eyeing the property. Now, my lady, these 7 plots that I said, which are in Sitori village, 4 are in her name, purchased solely by her own income. I'll not go into the, I've annexed everything, my lady, but this is not relevant because only caution of law is involved here. And 3 joint income, but these are registered in the name of the husband. Now, amongst the sibling brothers of the late husband, only one brother is alive, elder to my late husband. My husband also regarded him as a father figure, and I do also. So now what happened, my lady? Starting from a notice, these are documents, that land documents. My lady, may I just show just to show page 69, my lady. Before that, page 64. 64. This is the trade license. The business that I'm running is Ring Dragon Fruit Farm. That is my enterprise. Now, 69 page. Sanction approval. Financial funding from the NEC.
Expansion of trade.
Yes, this is in April 11, 2017. Expansion of dragon fruit farming at Sitovi. Yes, my lady. So about rupees 171.80 lakhs was sanctioned by NEC. Now, my lady, I'm just showing this that I have not used any of the money from my husband to develop my business. So after this, after the debt, page 95. This is when it started. This was
Page 95.
2019. My lady, 16 January 2019. There was a notice in the Nagaland Post. Page 95. Purchasing of land, selling or taking loan against the property of late Katie Thomas Ma, house number such and such at ISBT Colony, Pune, Bazaar, Dimapur, and Dragon Fruit Farm at Shitoli Village, Dimapur, without the consent of his bloodline and relatives, will be doing so at his own risk. So I cannot sell off the property, I cannot take loan. I have not taken any loan, but I cannot sell it. So this is how they started. After this, page 96, my lady. Another circulation was here. This was delivered to me personally. This dated 6/8/2023. And that a family meeting will be held. Now, my lady, I was not very familiar or close with any other members of my late husband, except for the brother who's still alive. So I contacted him, and he said he has nothing to do with this. Without his knowledge, without his consent. So I didn't go. This is done by some. Now, who are these people? They are the sons, there is nephews of the other brothers, and their wife also even. Now, then.
But they are no more. They have also passed away.
The brothers.
The other brothers.
Other brothers have passed away. Only one brother.
Except that one.
So the sons of the brothers who have passed away, other private respondent here also. Now, my lady, page 97. Then this notice came. This was also sent to me, page 97. Now, may I read this? This is addressed to the Okoso Village Council. That is my parents' village. Such and such. Dear Chairman, I trust this letter will find you well. I'm writing on behalf of the family members of late Katie Thomas Mark, and with utmost respect, on behalf of my lady, my policy, on behalf of late Katie Thomas, and with utmost respect to bring your attention to the matter request the collective wisdom and cooperation board of Desivenue and Okoso villages. Mrs. Lucy, the wife of late Katie Thomas, has unfortunately remained disconnected from the family members despite numerous attempts to organize a meeting in goodwill. This situation has deeply affected the sentiments of the family. In the light of the significance of community harmony and understanding, we propose the summoning of a joint village consultation meeting with the chairman of Aforesaid Village Council. The purpose of this meeting is to address the concern related to Mrs. T. Lucy and an amicable resolution that preserves the value and unity of broader communities. I kindly request your assistance in coordinating and facilitating this meeting purpose of the following details. So this is what. So I was also told to attend this meeting. I went along with my relatives. On the way, I stopped at Kohima. I went to the elder brother's brother. I met him. He says, no, he's not coming. He's nothing to do with this. So he didn't come. But I went along with my parents' relatives. I went there. My lady, I was.
Then this 99. Page 99.
On this day, a lot of derogatory remarks were made against me. It was quite very, very humiliating. I went through it. So many allegations were made against me. And my lady, the most important thing is no such resolution was taken on the spot. After that, only we have to live happily together, that kind of thing. We are meant to sign on a sheet of paper to record our attendance, which have been closed. Know this. When did this come? My lady had specific date also issued. 19 February, right? 19 February 2024, this respondent number 3. Respondent number 3, John Ma, who is the leader of this family, who are doing these things against me, he came and gave it to me in the Purna Bajan. This. Then my lady, after that, my lady, what happened was I also wanted to get settled on this thing.
Page 99, resolutions. Not written during the meeting.
No, though they are claiming that to be it's done, but it was never done. It was delivered to me on 19 February 2024 by respondent number 3. Then my lady, page 107. So therefore, I said I also wanted to get widow alone, my lady. She also was harassed. So therefore, she requested the families, and the family decided that we'll settle this matter. So one of the family members from my parents' side wrote this letter to the elder brother. Yeah, calling for a meeting.
107.
Yes, 107. And here, my lady, even a proposal was made at page. It is the last paragraph, 110, saying that there are these lands were purchased, how they were purchased, everything is said. And there are 3 lands in the Sitawe village, which is village pata recorded in the name of my late husband. I'm willing to give it to the elder brother. That offer also was made. But on the day of meeting, no one turned up. So therefore, after that, now, my lady, the village pata is 3 of the plots are in the name of the husband. So we also did not know who actually is making the complaints. And we said, she's decided that this patas also should be changed in her name now, since the person in whose the pata was recorded had expired, her husband expired, the 3 lands she decided to shift. In fact, to find out who are this person, that's when she went to the village council members. They said, no, first take care of the notice that was published in 2019. So she came out with a notice on page 111. So she said that I'm the wife of late Katie Thomas, who passed away on such day. During our marriage, we purchased lands at Sitawe, so covered by Sitawe village council partner number such and such. After the demise of my husband, I have become the sole owner of the said lands. I'm applying for part of the said land in my name. Anyone who has any objection can file written objection before the Sitawe village council. So then the objection came, my lady, 112. Objection in the newspaper again. And this is when we came to know the person. She came to know the person because the name of the person for the first time mentioned here in this. And they are the respondents, private respondents, 3 to them. Then my lady, yeah. Then page 113. Before this something happened. After this, my lady, what happened was December 16, 2024. This respondents now it's apparent. They went to the farm, broke open the gate. I have a farmhouse also. They entered the farmhouse. And then again on 18 December, again they entered the state one night overnight. On the first day, no, on the first on the first day they left without staying over. On 18 December 2024, they had entered. I came to know, and they were staying there. So I went to the police station, Kohima police station. I lodged a complaint. Then the policewoman, instead of registering, I had the number of this respondent number 3. So she talked with him, and they left. After that, on 28 December, again they came. Again they stayed over. No? They stayed over again. They broken the gate, my lord, the doors, gate, and entered. And they had even told the caretaker that we have come to take over this property. Then I again went to the police this time. So again, somehow they left. Huh? After that, they left. Then on 7th January 2025, at around 9 p.m., someone, I cannot name them, at night came outside my house, started honking, shouting, all that kind of nuisance was made. I complained to the ward members. They came and then they left. I've mentioned CCTV camera is recorded mine. Then I've also gone and made complaints to the police station, women's police station. Then again, my lady, they also filed a counter FIR in the Kohima police station. I was summoned, I showed all the land documents, and the police understood that it is my land. So then after this, they summoned me again, my lord, my lady, 114. Through the village council again, I was summoned, saying that I violated the resolution passed earlier, and I've also used the name Mark. I've always been using the name Muli only, title Muli, never used the title Mark. Even my husband, his official name was Katie Thomas, not Mark. So now, after that, my lady, this someone I got, 114, then I did not go. This time I did not go. Absolutely no jurisdiction. She also received legal advice that these people, this village council has no jurisdiction at all. So there's no point, no need to respond. Then 115, this order was passed. Now, my lady, because I'm not using the title Mark, because so then contempt, because of that, there's contempt. I don't know if the village council has the authority. Another thing is, I've not responded without jurisdiction. Why should I do? No jurisdiction. They don't have the jurisdiction. Then termination. My lady pension. It's governed by statute. How can the village council on the basis, even on the basis of custom? It's governed by statute, my lady. Immovable properties, my lady.